Hey, Mr. Lee, how are you?
Good morning, Mr. Ryan. How are you today?
I'm doing fine, thanks. Good.
Who is the lead? Is it you?
Miss Hurst to probably be, she's more senior, so she'll take the lead on most stuff, and then I'll just whatever. It's kind of doing it together. So
All right.
so we'll just hang out here, and I'll admit these folks. She wanted everyone on board at 8:50, so I'll give it 2 more minutes.
All right.
So I'll just stop my video and mute myself.
All right.
Thanks. Let Mr. Lee and his audio works fine, Elizabeth. You're muted.
Thank you.
There we
Good
go.
morning, Mr. Lee.
Good morning, Commissioner. Hearing examiner.
How are you?
Good. How are you?
Good, good, good to see you.
Good to see you too.
It's been a little while.
It has been.
And is there anything that we can provide you with?
No,
No?
I think I'm
Okay.
good.
Okay, awesome.
Should we admit all?
Let's. Yes. Yeah, I think what I would like to do though is, for the public commenters, I'm going to try to admit one at a time based on the list that we have.
Okay.
I think it might be easier that way. Just to let everybody know who's joining now. Mr. Ryan has already got us hooked up to YouTube. So we are already live streaming. And I just need to know whether or not anybody's going to have anything procedural that we need to deal with. We got. I'm not used to saying that. I have to tell you, after 25 years, I kind of like having a co-hearing examiner. All these years where, parties had other people with them. They had the attorney and the witness, and, case coordinator and all those kind of things. And so I'm glad about that. Again, to the people that just joined, we're already streaming on YouTube. So again, if anybody has anything else procedural that we're going to need to deal with, now's the time to talk about that. I think we pretty much got things in order on Friday, and with the exception of an email this morning regarding, well, actually, I guess we got a couple of emails over the weekend, and okay, well, I'm not hearing anything.
Ms. Gerson has something.
Oh, hello there, Miss Gerson.
I'm sorry.
I see your little hand there. Okay.
Thank you, Madam Hearing Examiner. I just wanted to recall the email Kara Lynch had sent. I think
Yes.
Friday afternoon. And I appreciate all of the guidance you provided at the pre-hearing on Friday about attorney appearances, but since I, as Pro Hoc Vitae counsel, need permission to appear not accompanied by local counsel, I just wanted to be extra sure to get your, consideration of her request to miss part of this afternoon's hearing before we begin.
I don't think that is potentially an issue, Ms. Gerson. I think you've been appearing in our proceedings and with the understanding that if there is something that you need to be informed of with regard to a local rule or something, that you would agree to contact Ms. Lynch. Okay.
Your Honor.
Okay, I just need to add okay. Anything else that we have? Can't hear you, Chris. Oh, you're on the phone. Okay. All right, well, we will begin here momentarily. I'm going to go by the official phone clock. My work computer likes to be 10 minutes early, which is fine. But your alts may not be that way, so.
Yeah, sorry, Ms. Hurst. I was just calling Anna, Ms. Kippenbrock. I don't see any of the public commenters waiting in the waiting room or being, seeking admission. It's, 3 minutes, 2 minutes to 9. So perhaps if they appear shortly after 9, they will. But they may not, because, you know, this might be just a bit too complicated for some folks.
Okay. Well, I hope we're gonna get them. Did you ask her to verify that the link she sent is the same link?
Yeah, I mean, the link to the YouTube meeting this morning,
Yes.
well, to the Zoom meeting, yeah, she did say she sent it to them during the call. I mean,
Okay.
I could ask her to confirm. I'll just do that to be extra certain. I'm gonna mute myself.
Okay. Thought maybe we were gonna have someone in the hearing room. Somebody followed me into the building this morning. I asked if I could help him, and it was before 8. And he said no. He went on up the stairs, so. It brought up a interesting question, though, of if someone did show up in the hearing room, how we could accommodate that person viewing the hearing. I think we'd have to have the YouTube on in the hearing room if that happens this week.
So Ms. Kippenbrock confirmed she did send the correct link to the folks, and we do actually have one of the commenters now waiting.
I
in the
know.
waiting room, so
I see that number 4.
Yep.
Excellent. Okay, well, let's check the official Elizabeth. Clock. I think it's 9. So if we don't have anything else procedural that we need to deal with, I think, again, we are live streaming. I just remind you of that. And Mr. Lee, if we're ready, sir.
Yes, ma'am.
Very well. Excellent. Good morning. My name's Elizabeth Hurst. I am, along with Christopher Ryan, the designated hearing examiners in case number 21-00267 UT. This is in the matter of the application of New Mexico Gas Company Incorporated for approval of revisions to its rate, rules, and charges pursuant to advice notice number 87. This is the date, time, and place for a hearing in this matter, as was set forth in the procedural order that I issued in this case on January 24th, which was amended with regard to table 2 for notice purposes. The notice was published in a newspaper of general circulation in the counties in which gas company provides service, as well as being sent to its ratepayers. Further, gas company did as instructed, notify its email customers, and there was an affidavit of publication, web posting, and individual notice filed in this case. Also, along with hearing examiner Ryan and myself, is Mr. Lee, our court reporter. Gas company has requested an expedited transcript in this case. Should anyone need anything to do with the transcript, they need to contact Mr. Lee. And I believe with that, I would, again, now that we're on the record, I do remind people that the hearing is being streamed via YouTube. And it's necessary for the parties to, the streaming will not be turned off during luncheon or breaks. And if they don't want anything streamed, then you'll need to mute yourself and or shut your video off. Okay. With that, I believe I would like to go ahead before we take our public comment and have the parties introduce themselves. And let's begin with the applicant in this case, New Mexico Gas Company. So, Mr. Domi, if you would enter your appearance, sir.
Yes, Madam Hearing Examiner. Tom Domi, D-O-M-M-E, along with Brian Haverly and Nicole Strausser. Nicole Strausser is the General Counsel for New Mexico Gas Company. So it's Tom Domi, Brian Haverly, and Nicole Strausser on behalf of New Mexico Gas Company.
Very well. Thank you, sir. Now we'll have our intervener appearances based on their intervention date. Mr. Gould? You need to unmute yourself.
This is not going to be the first time I'm going to screw up this thing. Madam Hearing Examiner Peter Gould for NM area.
And for clarification of the record, Mr. Gould, will you define NM area, please?
Yes, ma'am. It is the New Mexico Affordable Reliable Energy Alliance. It is a nonprofit composed of large users on Gas Company of New Mexico system.
Thank you very much, sir. Mr. Gedko?
Don't believe he's present at this point.
Okay. Ms. Lynch?
Good morning. My name's Kara Lynch. I'm here on behalf of CCAE, along with my co-counsel, practicing ProHoc Vijay Sarah Gerson. She represents CCAE and is a senior attorney for Earth Justice.
Thank you, Ms. Lynch. And did you define CCAE, please?
Oh, Coalition for Clean and Affordable Energy. Thank you for that reminder.
Thank you. Ms. Nanasi?
Good morning, Madam Hearing Examiner Hurst and Hearing Examiner Ryan and colleagues. My name is Marielle Nanasi, and I am the lawyer for New Energy Economy.
Thank you. Ms. Beatles?
Yes, good morning.
Good morning.
Good morning, Madam Hearing Examiner, Mr. Hearing Examiner, and colleagues. Sydney Beatles for Western Resource Advocates.
Thank you. Ms. Norval or Mr. Meyer?
Morning, Hearing Examiner Hurst and Hearing Examiner Ryan. My name is Irene Norville on behalf of the federal executive agencies. Thank you.
Ms. Norval, will you be appearing all week, or will you be joined by Mr. Meyer?
Yes, I will be appearing all week. And if we continue on to next week in July 5th through 8th, Mr. Meyer will be joining.
Very well, thank you. Ms. Park, good to see you again.
Good morning, Hearing Examiner Hurst and Hearing Examiner Ryan. Julie Park on behalf of the city of Albuquerque.
Thank you. And Mr. Najjar.
Good morning, Dan Najjar and Jared Najjar on behalf of the Incorporated County of Los Alamos.
Hello. And Mr. Black.
Good morning. My name is David Black, and I am the lawyer for the Public Regulation Commission Utility Division.
Good morning, Mr. Black.
Good morning.
Well, we have our appearances except for the Attorney General's office. Anna, our assistant, if you are listening, would you please send an email to Mr. Gedko? Very well. Next, we have some people that we had 9 people sign up to give public comment. In this case, we were notified over the weekend that one person was unavailable due to a work commitment. So that leaves us with 8, but right now we just have we have one person in the waiting room.
But we did.
Ryan,
Yeah,
did you
No,
admit?
she's sorry, she just left actually. Miss Cianci, I hope I'm pronouncing that correctly. Cianci. She just left the waiting room. So I don't know where she's gone. If Miss Cianci can hear this.
Come back. We're ready for public comment.
There she
There
is.
you are. Okay, I'll go ahead and admit her.
I think I did already, yeah.
Okay, very well.
There she is.
Okay, good morning. Well, I'll wait till your audio is actually. Good morning, Miss Cianci. You want to tell me how to pronounce it? Cianci?
Cianci.
Cianci?
Yes.
Good morning. My name's Elizabeth Hurst, and I'm one of the hearing examiners for this case. And you have signed up to give public comment, and I believe you have been instructed that public comment is limited to 3 minutes.
Yes.
And just to let you know, in addition to this Zoom, our hearings here at the commission are being live streamed on YouTube. And if you would just state your name and your address, and whether or not you're a customer of gas company, after that, your 3 minutes would begin. All right?
Sure.
If you can spell out your name as well.
The court reporter would like you to spell your name also.
Oh, okay. Janice, Janice, Cianci, Cianci. My address is 5936 Full Moon Ave, Northwest. That's Albuquerque, 87114. And yes, I am a customer of New Mexico Gas.
Excellent. Go ahead, please, and give your public comment.
Well, the reason I'm here today is it just seems like everything is going up in price, regardless of what it is. It's, the gas, it's, the gas at the pump, it's groceries, everything. The only thing that's not going up is our income. And I did a little research, and I'm looking at the parent company for New Mexico Gas, and I believe it's pronounced EMRA or Emera. Is that correct?
It would be Emera, ma'am, Emera.
Emera?
Yes.
Yeah, and I read an article through the Halifax Examiner, which was written on 3/17/22. And, I see the amount of money the top brass is making, and it just, it's a lot of money. And I make pennies of that. I am on a limited income every month. So every penny that comes in is, I have to budget. I also read that the shareholders saw a 4% increase on the 2021 dividends and a total shareholder return of 22% on their investment. I don't even make 1% on my small savings account. So you got, I believe there's money being made that can be found rather than having to bring that cost to the consumer. And I understand, you know, you want to move forward with different, excuse me, you know, to make progress and to go green and all that stuff. But I just think right now, I don't think it's a good time to ask for any increases with everything that's going on in this economy at this time. And I would have to ask the commission not to approve the increase for the gas company at this time. And that's all I have to say.
Thank you very much, Ms. Yancey, for your taking your time to come and give the commission public comment. We appreciate it.
Thank you. Am I free to leave now? Or?
Yes, ma'am. Yes, ma'am.
Okay.
You can leave. Thank you.
Thank you.
I don't see that we have any other public commenters in the queue. I can share, or I would like to put on the record, I guess, that there were 5 public comments that were filed with the commission. And I can characterize them as being opposed to gas company's application. Those comments were filed by Dawn Agnello from Los Lunas. It's Agnello. Jeffrey Burrill, Burrill from Albuquerque. Diana Clark from Los Ranchos. Lynn and Sharon LaClaire, L-A capital C L-A-I-R from Los Lunas. And Dane Hubley, Hubley. And he did not say where he was from. Very well. Since we don't have any of our other public commenters at this particular time, I believe that we can go ahead with the other procedural items that we need to address before we begin the evidentiary portion of our case. Several of these procedural items were discussed at the pre-hearing on Friday, the 24th, and I can characterize them as primarily being requests regarding witness order and or attorneys being excused for portions or all of this case. Just to orient anyone who might be unfamiliar with the proceeding who's listening on YouTube, the parties in this case have reached and a stipulation, also known as an agreement. And the stipulation has terms and conditions that they provided testimony on, and one of the main things that persons listening might be interested in, whereas the original request that was noticed to gas companies' customers was a request for $40.7 million. The stipulated agreement is for 19.3. One of the procedural items that the parties have requested is that witnesses for whom there are no questions, that testimony be stipulated in, and upon no objection for that particular procedure, hearing examiner Ryan and I have decided that we will allow stipulation of some of the testimony where the commission or we, the hearing examiners, have no questions. And that would be done pursuant to verification of the particular exhibit as introduced by the party is in fact the exhibit that was provided to the court reporter via the Dropbox order issued by hearing examiner Ryan, and there being sufficient verification of the witness in that exhibit as to the witness's identity by verification, affidavit, or affirmation. Further, there being no objection by any party, and the fact that the parties have, as indicated in the pre-hearing memorandum filed in this case, agreed already to this procedure. This procedure would allow the particular exhibit to be admitted without the necessity of the witness being present and subject to questioning. The parties in this case have already waived in the pre-hearing memorandum the opportunity to cross-examine any witness. Each other's witness initially. The agreement to allow stipulating exhibits is also subject to the condition that should questions become available or necessary for the stipulated witness's testimony later in this hearing, the parties agree, party offering the exhibit agree that they will make that witness available. Additionally, the stipulated exhibit witness testimony is being admitted subject to the party's understanding that in its determination of relevancy of the particular evidence, the commission will determine what weight, if any, to give to the evidentiary exhibits. With that understanding, I believe that we can now go ahead and address the procedural issues related to appearance and witness testimony. And I believe Ms. Nanasi, you are first in that regard and have made 2 requests. The first request has to do with your witness testimony. Is that correct?
Yes, ma'am.
And would you like to go ahead then and offer your witness's testimony to be stipulated into the record at this time?
Yes, please. Once again, for the record, my name is Marielle Nanasi. I am the attorney for New Energy Economy. Without objection from either the parties or hearing examiner Hurst or Ryan, New Energy Economy seeks admission of the expert witness testimony and exhibit of Mark Z. Jacobson in support of the unopposed stipulation that was pre-filed in this matter on May 31st, 2022, per the hearing examiner's order. There are no changes or corrections. There was an affirmation that was included in Mr. Jacobson's testimony, and so I would seek the admission of New Energy Exhibit 1.
And in order to be more efficient, since the parties have already waived their objection to the introduction of the exhibit, I'm not going to call the roll through each exhibit. And it will be incumbent upon any party, if you've changed your mind, to enter your objection orally by raising your hand or indicating that you're objecting. I hear no objections, and pursuant to the agreement, the verification, the understanding, and the witnesses or the exhibit as you have described in EE1, Ms. Nanasi, that was in fact the exhibit that was provided in the Dropbox. Is that correct?
It is correct.
Very well. NEE Exhibit 1 is admitted.
Thank you so much.
Thank you. Additionally, Ms. Nanasi, it is my understanding, based upon the request that was discussed at the pre-hearing on Friday, you are asking to be excused from attendance during the proceeding. Is that correct?
It is correct, but I will be seeing you all via YouTube.
Very, very well, Ms. Nanasi. And again, if anyone has an objection to the non-attendance of any counsel for any other party, you need to make any objection known now. The granting of such a request, as was discussed at the pre-hearing, is subject to counsel's understanding that any matter discussed or procedural issue that happens, you're bound to the discussion and the determinations made while you are not here. As do you understand that, Ms. Nanasi?
Yes, I do.
And you agree to that?
I do agree to that.
Very well. And as I explained on Friday, the briefing dates have already been set in the procedural order that was issued back at the end of January. So that is not something that would be set unless somebody actually makes a motion to change it, and then it would be subject to an order. Therefore, with those understandings, And hearing no objection, Ms. Nanasi, your attendance during the hearing based upon your request is granted.
Thank you.
Thank you. And you're free to leave the meeting if you'd like to. Okay, additionally, hearing examiner Ryan and I were informed at the pre-hearing on Friday that staff had made a motion to stipulate in the testimony of staff witness Martinez based upon an emergency health situation for Mr. Martinez. And that was discussed on Friday. And then after reviewing the testimony and the motion, hearing examiner Ryan and I have made a decision, again, subject to all the other stipulation requirements that have already been enumerated in the record, to grant your motion, Mr. Black. So if you at this time would like to offer your exhibit, sir.
Thank you, hearing examiner Hurst. At this time, staff offers as Exhibit 6 the testimony of Timothy A. Martinez in support of the unopposed stipulation, as well as, this is odd, the portion of Mr. Martinez's testimony contained in Staff Exhibit 3, which is staff combined testimonies in response to the June 6, 2020 bench requests by hearing examiner and to the June 8, 2020 bench requests by hearing examiner for commission staff.
And staff exhibit 6, Mr. Martinez, testimony in support of the stipulation. Were there any additions, corrections, or deletions to that testimony, Mr. Black?
No, Your Honor.
And was there a verification or affidavit from Mr. Martinez in exhibit 6?
Yes, there's an affirmation.
And was exhibit 6, the exhibit 6 that you're referring to, was it provided pursuant to the Dropbox Word?
Yes, it was.
Okay. Hearing no objection to staff exhibit 6, it will be admitted. Mr. Black, as to staff exhibit 3, which you have identified, contains portions of Mr. Martinez's testimony from June 6th and June 8th bench requests. Were there any additions, deletions, or corrections made to Mr. Martinez's portion of staff exhibit 3?
No, there were not.
And did Mr. Martinez include verification or affirmation in that testimony?
Yes, Your Honor. He included an affirmation in lieu of an affidavit.
Very well. And was staff exhibit 3 provided pursuant to the Dropbox order?
Yes, Your Honor.
Very well. Since it contains other testimonies, I'll make a, and there's no objection, I'll make a provisional ruling that at least that portion of the exhibit will be admitted, and that will be subject to admitting the whole exhibit with the other party's testimony. Mr. Black?
That's agreeable. Thank you, Your Honor.
All right, anything further with regard to Mr. Martinez?
No, Your Honor.
Very well. Also, for the record, I'd like to mention that part of what was discussed on Friday with regard to Mr. Martinez's stipulated testimony was an offer by staff to substitute another witness to adopt that testimony if it was the preference of the hearing examiners. At this point, hearing examiner Ryan and I do not believe that is necessary. Should that become necessary later in the hearing, we will so advise. Mr. Black?
Thank you.
Thank you. Additionally, staff also filed, we were informed Friday of a staff notice concerning another witness, staff witness Ramey, who has jury duty this week and will not be available until next week. Is that correct, Mr. Black?
Thank you, Your Honor. I received on Friday afternoon an update where Georgette Ramey will be available. She expects to be available during this week, but it will be on a day-by-day basis because potential jurors have to call in every morning to find out whether or not they will be called to serve on jury duty. So I have not received from her yet this morning an indication that she would be free today, but I will check every morning with her. So hopefully that motion is unnecessary, or excuse me, that notice needs to be updated.
Very well. If you could just keep us updated on that.
I will. Thank you.
I appreciate that, Mr. Black. We're hoping to get the hearing complete this week and not come back next week, but obviously we will take the time that we need to do that.
Thank
All
you.
right.
Staff will make every effort to accommodate that schedule. Thank you.
Very well. The next item of procedure that I have that we need to take care of, Ms. Lynch, is with regard to your request to be excused for portions of this hearing. You made that request?
Correct. Thank you, hearing examiner.
Very well. Again, subject to the same conditions for Ms. Nanasi of being bound by what happens if you're not here to participate, and there being no objection, Ms. Lynch, your request to be absent from portions of this hearing and allow your co-counsel to be here subject to any consultation she might need from you regarding local rules is granted. All right.
Thank you. So at any time, CCAE will be represented in this hearing.
Very well.
Thank you.
Thank you.
Madam Hearing Examiner, this is Ms. Beatles.
Just one second. Yes, ma'am.
Thank you.
I'm next to you.
Thank you. Our organization, Western Resource Advocates, is having the first annual retreat of, since in person for many years now, and it's going to be in Santa Fe over the rest of this week. And so I may send you an email asking for permission to be absent from this hearing to attend any of their like more substantive type sessions. So I would put my request in email, however, if that's acceptable to the hearing examiners.
And Ms. Beatles, as long as you understand you're subject to the other conditions, that will be fine.
Yes, of course.
Okay, very well. The next request, or I guess just information we received, I think this morning, and it had to do with Mr. FEA witness O'Donnell, and that he now has some constraints with regard to his appearance. And after discussing this, hearing examiner Ryan and I are in agreement to we will accommodate Mr. O'Donnell's schedule change. All right, Ms. Normal?
Thank you.
Very well.
Sounds good. Thanks.
Okay, the next procedural item that we need to deal with.
Madam Hearing Examiner?
Mr. Najjar.
Yes, thank you, Madam Hearing Examiner. I think I sent you and Hearing Examiner Ryan an email as well, indicating that for family health issues, both counsel for Los Alamos may be absent for portions of the hearing this week. I cannot at this time identify when that would occur, but I just wanted to be on notice and let you know that, and let you know that we understand and accept the risk of not being present for any portion of the hearing.
All right, very well, Mr. Najjar.
Was that Daniel?
Yes,
Thank you.
thank you, Mr. Lee. Okay. Very well. If we don't have any other requests from parties with regard to procedure, parties were informed at the pre-hearing on Friday, the 24th, that there were witnesses for which hearing examiner Ryan and I had no questions, and therefore, subject to the stipulation of the exhibit requirements, we were willing to have certain testimonies stipulated in and the two witnesses are gas company witnesses. So, Mr. Dome, if you would like to address Dr. Khan's testimony, please.
Yes, Madam Hearing Examiner. The company would request stipulated admission of the testimony of Dr. D. Khan, Deidre Khan, Deidre M. Khan. That is exhibits 33 and 34 as identified by the company. Both of these two exhibits were deposited in the Dropbox. And so what I'm asking for is stipulated entry of the two exhibits that are in the Dropbox. We agree to all of the conditions that you have placed on this stipulation. There was an affirmation, a testing under perjury, under the penalty of perjury, that this read and the testimony is true and accurate. And those were signed by Ms. Khan. There has been no objection introduced by anyone to the admission of this testimony, and there are no changes or corrections to this testimony. And Ms. Khan, who's currently in Ireland, will make herself available next week if need be for any questions, and or if this week we might be able to work it in, but she will make herself available for any examination, Madam Hearing Examiner.
Very well. Based upon your identification of Dr. Khan's and Mr. Lee, that's K-A-H-N-S, in
Thank you.
that correct?
Madam Hearing Examiner, this is Mr. Gould. On the pre-hearing memo, those numbers don't line up. Is there correction that I did not get?
Oops, Madam Hearing Examiner, I made a mistake. It's Exhibit 33 and 34. My apologies.
Okay, now that's what I had written down.
Oh,
Mr. Gould?
I showed 30 NMGC 33 to be Yardley direct and 34 to be Yardley in support of the STIP. This is on my copy of the joint pre-hearing memorandum filed on June 17th.
I believe that gas company's list of exhibits, Mr. Gould, was updated in the Dropbox.
Okay, well, I'll go back and
And
check that. Sorry about that.
That's okay. And just so we're on the same page, I can tell you that I downloaded the exhibit list from Dropbox and gas company, and 33 is Deidre M. Khan, PhD, direct testimony. And 34 is Dr. Khan's testimony in response to the hearing examiner's order issued June 21st. Hearing no objection,
No objection.
subject to the verification and identification of Dr. Khan's testimony provided. Exhibits 33 and 34 for gas company will be admitted. And just, Mr. Lee, just because I didn't hear Ms. Nanasi say it, her witness, Jacobson, is also Dr. Jacobson.
Thank you, ma'am.
Thank you, sir. Go ahead, Mr. Dome. The other witness that hearing examiner Ryan and I did not have questions for was Mr. Avalon.
Madam Hearing Examiner, this is Brian Haverly. I'm going to move the admission of Mr. Avalon's testimony, if that's okay with you.
Yes, sir.
Okay. So New Mexico Gas Company would respectfully move for the admission of the direct testimony and exhibits of Davisal Avalon, which is NMGC exhibit number 28. It was provided in the Dropbox. The testimony has been verified by affirmation. There are no changes or corrections to the testimony. No party has objected to the admission of the testimony. Mr. Avalon will be available to testify live in the event that anybody has questions for him in terms of the hearing examiners or the commissioners. And with that, Madam Hearing Examiner, I would move for the admission of New Mexico Gas Company exhibit number 28.
And Mr. Havley, you can verify that Mr. Avalon's testimony in MGC exhibit 28 was in fact a document that was downloaded into the Dropbox.
Yes, ma'am.
Very well. Hearing no objection, Mr. Avalon's testimony in MGC exhibit 28 is admitted.
Thank you.
Thank you. Okay. Well, unless hearing examiner Ryan has any other procedural matters, I believe that we are ready to begin the live witness portion of our hearing today.
No, you've covered everything, Ms. Hurst.
Very well. And and just for explanation purposes, because of witness constraints regarding availability this week, we are not going to follow the normal presentation order of parties. We're going to take some witnesses out of order in order to accommodate their schedules. Therefore, we are actually beginning with WRA's witness, Mr. O'Connell. So, Ms. Beatles.
Yes, thank you. And thank you for accommodating Mr. O'Connell's schedule. Staff calls Patrick J. I'm sorry, I said staff. It's been over 3 years. WRA calls Patrick J. O'Connell.
And we miss you, Ms. Beatles, and we also miss Ms. Park, who also was a former staff attorney. Good morning, Mr. O'Connell.
Good morning.
How are you? Long time no see.
Great to see you this morning.
Yeah, I think last I saw you testimonial wise was for P&M's IRP case a few years ago when you were still employed by them. Mr. Lee, would you swear the witness, please, sir?
Yes, ma'am. Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you.
Thank you, Mr. Lee. Go ahead, Ms. Beatles.
Yes, good morning. Do you have before you, Mr. O'Connell? Well, let me start with your name and your employer and your position.
Good morning. My name is Patrick J. O'Connell. I am Western Resource Advocates Clean Energy Program Deputy Director.
Thank you. And do you have before you a copy of the exhibit we have labeled as WRA Exhibit 1, your testimony in support of the stipulation filed May 31st?
Yes.
And do you have any changes or corrections to that testimony that changes the substantive meaning of any of your statements?
No.
And if you were to answer today those same questions in WRA Exhibit 1, would your answers be the same?
Yes.
And are they true and correct to the best of your knowledge and belief?
Yes.
I move the admission of WRA Exhibit 1.
Hearing no objection to, Ms. Beatles, is WRA Exhibit 1 the Mr. O'Connell's testimony is the version that was put in the Dropbox?
Yes.
Very well. Hearing no objection, WRA Exhibit 1 is admitted.
Yes, and I now pass the witness for cross-examination or questions from the bench.
Very well, thank you. And again, the parties have all waived the initial cross-examination, so I have a few questions for you, Mr. O'Connell. And if you would turn to your testimony on page 2, question posed at line 9, does the stipulation result in a fair result? Does the stipulation result in a fair result of this case? In that lines 10 through 16, you begin affirmatively that it does. And you say at line 11, prior to entering settlement negotiations, WRA and other parties to this case analyzed the company's request. How did you do that, Mr. O'Connell?
How I did that was I propounded quite a bit of discovery. I had quite a few questions about particularly the greenhouse gas issues in this case. And so part of discovery was updating my memory of how the gas company system operates. Part of it was just understanding what had been provided in the application. And so I was working through that information plus knowledge that I have obtained through my job to start developing positions that I was prepared to present in testimony, direct testimony in this case, and was on the cusp of doing that when we were contacted for settlement negotiations.
And I noticed in your summary of your background and qualifications, where you say that you work for Public Service Company of New Mexico, also referred to as P&M, for 22 years. Correct, sir?
Yes.
And you say on page 1, beginning at line 15, from 1998 through 2007, I worked in the gas supply planning department of P&M's gas utility, the predecessor to New Mexico Gas Company. That's correct?
Yes.
And so basically then for 9 years, you had an intimate knowledge of gas company workings.
Yes.
So when you were propounding your discovery, were you in your position now with WRA, were you concerned with with gas companies' total application? For example, did you propound discovery like on revenue requirements and rate design?
I did not, but I did read the discovery that was propounded by all the parties in this case.
Your testimony beginning on page 3 references the greenhouse gas emissions reduction initiatives, correct?
Yes.
And further on your testimony on pages 4, 5, and further, you provide testimony on paragraphs 21 through 27 of the stipulation, correct?
Yes.
And is it fair to say, Mr. O'Connell, that those paragraphs of the stipulation actually deal with greenhouse gas emissions and other carbon reduction agreements that the parties entered into in this case?
Yes, I would state that a little differently, that it deals with proposals the company made and how the company operates in a way that then affects greenhouse gas emissions. So that might not be different than what you said, but apologies, I'm an engineer.
and you know, and I hesitate to characterize anybody's testimony. My point is, or what I'm trying to figure out here with your testimony, Mr. O'Connell, is that there's several other paragraphs to the stipulation, aren't there?
Yes, there are.
And once you get past the background section, for example, if you begin with page 8 or paragraph 8 of the stipulation, That section is entitled Base Revenue Increase and Stipulated Rates, isn't it?
Yes,
And on page 5, beginning at paragraph 17, that section begin or is labeled as IMP regulatory asset, isn't it?
yes,
And it isn't until paragraph 21 that you get to the section that's labeled greenhouse gas emission reduction initiatives in this case, correct?
correct.
Then on page 9, under additional provisions at paragraph 26, that also has to do with a greenhouse gas compliance filing, doesn't it?
Yes, it does.
And then paragraph 27 also has a potential effect on greenhouse gas emission by changing rate 39, doesn't it?
Yes.
So I'm wondering if your focus, sir, and the focus of WRA and several of the other parties in this case actually concentrated on paragraphs 21 through 25, perhaps also with the addition of paragraphs 26 and 27.
That was my primary focus. I did observe in my testimony that having participated in the settlement process, I believe all the issues that are addressed in the settlement were the focus of interveners in this case. I observed that these are experts and had done a level of homework at least similar to mine. And so that's why I'm here supporting the entire stipulation. I'm providing in testimony the example of the rigor that we put in to those paragraphs to support the conclusion that parties brought their best game to analyzing the application and the stipulation as a whole.
But is it fair to say that you didn't concentrate, nor was your focus on the revenue requirement?
Yes.
As part of your preparation to negotiate and or provide the testimony in support of the stipulation, did you go back and did you do any review of the prior rate case? The last rate case 19-00317.
Yeah, I'd read the final order in the prior rate case. And just also to back up a little bit, in the sections of the stipulation that I focused on, there were revenue requirement elements in that application. So while it was the focus were the paragraphs I've highlighted in my testimony, it's not fair to say those didn't implicate the revenue requirements.
What about rate design?
I did not focus on the rate design, no.
While you were preparing to enter settlement negotiations or prior to settlement negotiations, when you were analyzing the company's request, did you develop a litigation position?
Yes.
What was it?
The litigation position was going to focus on the items that I've described in my testimony. On page 3, lines 3 through 11.
And what is the connection with the emphasis on leak repairs? As set forth on page 4 of the section you just referred to?
I was looking at leak repairs, thinking about, as I say here, exploring the short-term and long-term climate impacts associated with each proposal. A leak by definition means a methane release to the atmosphere. So that was the intersection between leak repairs and climate impact.
Mr. O'Connell, did you read the responses to bench requests?
Yes, I did.
Are you familiar with the bench request issued by the commission back in January and gas company's responses?
I know I read that. The focus of my preparation for today was on the second bench request, so I need to refresh my memory.
Let me just find it. This response was submitted to the commission on 18 February of this year.
Does it have a Dropbox exhibit number?
I believe it does.
Madam Hearing Examiner, this is Tom Domi. That would be NMGC Exhibit 39.
Thank you, Mr. Domi.
Mhm.
I believe Mr. Wassine was the sponsor of that exhibit.
Yes, ma'am.
Are you there, Mr. O'Connell?
Apologies, my Dropbox list had the first list, not the second.
Okay, well, let's just see if you can answer. It's a pretty simple question. Basically on page 2. Oh, it's not got lines. The question is on B, letter small b. Please confirm your understanding that the Energy Transition Act in relevant part does not apply or relate to public utilities providing natural gas service. Gas company response was confirmed. By its terms, the ETA does not directly apply to a public utility providing natural gas service. Did you read that, Mr. O'Connell?
Yes, I did.
Do you agree with that?
I agree that the focus of the law that we refer to as the Energy Transition Act is electric utilities. I believe there is an indirect impact, though, from quite a few of these greenhouse gas reduction ideas included using more electricity.
Well, other than the Energy Transition Act, do you believe that there's some other statutory authority that requires or commission rule that requires gas company to participate in these reduction measures?
I can't recall a specific law or NMPRC rule requiring the gas company to participate in greenhouse gas reduction measures.
Okay, because I know on page 3 of your testimony, beginning at line 15, you say, Mr. Wassee, gas company witness, describes the company's agreement with and commitment to the greenhouse gas emission reductions called for in the governor's 2019 executive order, which you attached as an exhibit to your testimony, correct?
Correct.
And I just wondered if there was some other legal authority that you think is persuasive of this requirement, commitment.
Well, broadly, I think that the biggest legal authority there is the general provision that the gas company provide its service at low rates. So I believe that there is risk associated with continuing to rely heavily on natural gas, and that it's in the customer's best interests to focus the use of the natural gas for the use that the customers are purchasing it for. So things like leak reduction and studying conversion of compressor engines to electricity, vehicle fleet moving to electricity. I believe all those offer cost savings, and that is in alignment with the gas utility and every other regulated utility's service obligations.
Sir, I'd like to ask you about your testimony on page 6. The question posed at line 6 and 7, how do paragraphs 23 and 24 reduce greenhouse gas emissions associated with gas companies' operations? And you are testifying as to paragraph 23 of the stipulation at line 8, commits gas company to analyze electric vehicle options with the company when the company purchases passenger vehicles and trucks, and to show a preference for electric vehicles when feasible. So later on in that paragraph, well, you talk about paragraph 24, committing the company to an analysis of alternatives prior to rate recovery of future investments in CNG, which is compressed natural gas, correct, sir?
Correct.
Facilities. And I'm trying to understand the connection with that and your statement at line 16. At the same time, coal generation has become uneconomic, and New Mexico's electric utilities are abandoning service from coal plants. This makes using electricity for vehicle fuel less greenhouse gas intensive than compressed natural gas. I don't understand the connection between abandoning coal and using electric vehicle. Can you explain that connection to me?
Yeah, the use of electric vehicle, you'll be substituting electricity as your fuel for gasoline or diesel or CNG. As the coal units retire from service in New Mexico, the electricity supplied by the electric utilities within this state means that that fuel will have less greenhouse gas intensity per vehicle mile traveled than gasoline, diesel, or compressed natural gas. So the benefit of moving to electric vehicles, assuming models are available, is O&M savings, fuel savings, and then as a strategy to reduce overall greenhouse gas emissions in this state, it will also mean that traveling down the road will be associated with less greenhouse gas emissions.
Doesn't it seem counterintuitive Mr. O'Connell, for the gas company not to use gas and for the gas company to use electric?
I believe that, well, no. The goal here is to provide service efficiency to customers. And so in this case, electric vehicles development trends have resulted in the case where if you're purchasing electric vehicles, soon the cheapest option because of fuel and O&M savings will be electric vehicles. So the observation that making that cost savings for customers will also be associated with a reduction in greenhouse gas emissions, which is in line with the executive order that the gas company stated in its application.
Well, the fuel may cost less, Mr. O'Connell, but that doesn't necessarily mean that the use of the vehicle itself is less, does it?
Yes, electric vehicle has far less maintenance expenses associated with it than a combustion engine vehicle does.
What about the upfront cost of an electric vehicle versus a gasoline or diesel or compressed natural gas vehicle?
Electric vehicles are becoming more cost competitive every day. So while there has traditionally been a price premium for buying an electric vehicle, that as more models are introduced and more manufacturers are offering models, the prices are coming down. And so similar to, gas companies paying a premium for compressed natural gas vehicles over diesel, the fuel and O&M savings will overcome that cost differential.
In this lifetime?
I believe in some cases that is happening right now, especially with the smaller vehicles.
Sir, I'd like to look at your testimony on page 9. The question posed at line 4, how will this agreement benefit New Mexico Gas Company's customers? And you make the statement on lines 5 and 6, low-income households spend a higher percentage of income on energy bills. What are you basing that on?
I'm just basing that on my experience working in the field. I had looked at an academic paper when I was writing this testimony, and that's what I'm paraphrasing here, but just multiple times over.
That be?
I should have footnoted it. I did not, but I can find that.
Additionally, sir, your testimony on page 10, the question posed at line 1, what is the financial assistance potentially available to New Mexico Gas Company's low-income customers? You begin answering that question and you refer to an MOU, which is my understanding that it is a memorandum of understanding that some of the parties agreed to. And you say at line 3, statewide funding for the Community Energy Efficiency Development, or CEED, block grants and money available through the Mortgage Finance Authority, MFA, total $16 million, and federal funds available through Energy Smart total about $30 million. That's your testimony, sir?
Yes.
Did you work with those programs when you were with PNM?
I worked with Mortgage Finance Authority programs when I was with PNM through
In what
PNM's
capacity?
PNM's delivery of energy efficiency programs.
Very well, sir. That's all the questions that I have for you. Thank you. Hearing Examiner Ryan, do you have questions for Mr. O'Connell?
I do, Ms. Hurst, but I was wondering if it's possible if we can take a very short 5-minute bio break, as they say.
Okay, we will take, I have about, I have 10:19, so let's come back at 10:30 and we will resume questions. Thank you. Okay, I think. I think we're back from our recess and hearing examiner Ryan.
Very good. Mr. O'Connell, how are you, sir?
Great, thank you. How are you?
I'm fine, thanks. The title you hold, sir, is Deputy Director of Western Resource Advocates Clean Energy Program.
Yes.
What does that entail? We've spoken before, and I think I have a general sense, but could you just describe your general responsibilities with that title?
My general responsibilities are to oversee and supervise the clean energy program employees working for WRA in New Mexico, Arizona, Nevada, and Utah.
As the clean energy deputy director, does that is your focus specifically on emissions reductions and questions about clean energy, or do you think do you that more broadly encompass things like rate design and the types of tasks Ms. Hurst was just asking you about?
It broadly can encompass the tasks Ms. Hurst was asking about. The goal of Western Resource Advocates is to fight climate change. How we do it is by working with utilities and in regulatory proceedings throughout the West. So we tend to intervene primarily in electric utility planning and rate case events, and then have also, as the definition of clean energy has gotten broader and there's more overlap between provision of electric service and gas service, we've also begun intervening in gas rate cases like we're doing here.
I asked in bench request the gas company, and I don't recall right now which witness I asked, but I do know I asked this question. Does emissions reductions a policy that guides their rate design? And the answer was no. Did that answer surprise you?
It doesn't surprise me.
Why would that be?
Rate design is traditionally about recovering the revenue requirement. And so it's an allocation of the cost of service to differently situated customers. And in this case, the greenhouse gas reduction measures were costs that all customers would benefit from. So it would be a reduction in the overall revenue requirement. So then when you get into the allocation of that requirement, does any one customer class bear any reason for a greater share of that savings? Those are the type of things you could expect. As discussed with Ms. Hurst, gas company is relatively new in working towards developing its greenhouse gas reduction programs. And I'd say that in these early days, not a huge impact on the revenue requirement. I mean, biggest example was the 2.9 million for the steam methane reformer in the phase 2 of the hydrogen blending program. But the other things like installing solar panels on the roofs of gas company buildings, that's kind of things that customers will save money over time. Is it a big material impact on the revenue requirement yet? I wouldn't say so. So that's why I'm not surprised that that hasn't followed through into the rate design element of the case yet. I predict it will in the future.
Yeah, and I guess that, I mean, one of the questions I asked, I wanted to ask you was, you know, is it, I don't know, what would it look like to have a gas rate design that is designed to minimize emissions? How does one do that? Like what would be the strategies? Or
Okay, so a good example would be a provision in the stipulation where gas company is going to go and look at electrifying compressor stations. That's a time of use opportunity that I believe the gas utility has. It's similar to a water utility. There is storage within the gas pipe system. Gas, by going to electricity to fuel some of its compressors, that provides a couple things. One, opportunity to reduce cost by using electricity rather than the more volatile commodity cost of gas. It provides opportunity just to save methane emissions because you're reducing the amount of methane running through the system. But because gas company, especially in the shoulder and summer months, could choose to pack the system early in the morning when the wind is blowing, they might be able to get a favorable time of use rate for that electric service, similar to what water utilities do. And then that could then translate through to customers. If there's a way for some of the larger industrial customers to shape their use throughout the day, that then complements what the gas utility is able to do with its own system. Those are the kind of things that could end up becoming rate design elements. But we're a few steps away from that right now. So just a prediction of the kind of thing that could happen. First step is the activities that are in the stipulation in this case.
All right, and so if I understood you, what you just described to me was a process by which the gas company can utilize renewable generated electricity to perform functions that in theory reduce emissions because they're using renewable sources or under some sort of time of use. But it's obtaining electricity effectively. I guess, is that correct? Did I understand what you just said?
Yeah, correct. There's multiple links in that chain that I just described, but one of them is use electricity and focus the use during hours of the day when electricity is cheap because renewable energy is abundant.
Okay. I suppose I still am, and I think right. So one of the things that I believe the glass company was trying to do to mitigate emissions, which obviously was stiffly resisted by lots of the interveners here, is the hydrogen blending, and I was sort of surprised with the resistance, not because, well, I guess you hear the references to hydrogen blending as something for the future. I guess I just wanted to ask you, as the clean energy deputy, like, is there any merit to that program?
I believe there could be. That's why in this stipulation, as I pointed out in my testimony, appropriately, gas company is proceeding with its tier 1 or first phase of their hydrogen blending program. My objections were the design of the second phase, which looked to be a situation where gas company would be increasing greenhouse gas emissions in the name of reducing them, because there wasn't any carbon capture, storage, or use associated with the production of hydrogen. So those are the kind of things that I'm expecting we'll get into when, as the stipulation requires, there will be a very good conversation and stakeholder outreach in between phase 1 and phase 2. I've observed that just from studying the issue, I'm not sure. I'm going into it skeptical, but that doesn't mean I won't go into it with an open scientific mind and could be convinced otherwise.
Okay. At page 3 of your testimony, and this sort of goes in the direction that Ms. Hurst was asking, sort of questions she was asking. So you write there, entering the settlement negotiations, WRA, this is at the top of page 3, beginning at line 2. WRA was developing testimony to ensure a result that reduced the impact of the company's operations on our climate change. And then, skipping those sentences as to avoid having to read a lot, going on line 6 there. WRA analyzed each of these activities by exploring the short-term and long-term climate impacts associated with each proposal. And as I read that, and I believe you've already confirmed this from Ms. Hurst, but I'll just ask you the question as well. My understanding of your testimony is you were really principally focused on questions relating climate change and emissions in your assessment of the stipulation.
That was the lens at which I'd entered my reading of the testimony. But by looking at it with a climate change lens, you end up thinking about things like company operations and cost of service to customers. And then I'd observed that just part of the application included the testimony from Dr. Khan, which showed that the fact that the climate is changing also has rate design implications for gas companies' customers in terms of the billing determinants that get used in the rate design phase. So it's not just the direct things that I've been focusing on in my testimony today, but just the bigger picture question of climate's changing, getting warmer. How does that affect the rates that gas companies going to have to charge? And that was something I thought was very interesting in gas companies' application. You know, my experience working for gas utility a while ago was that I wouldn't have expected that testimony to have been provided. So I think just we're in a world where thinking about changing climate and its effect on cost and operations of an essential service like what's provided by New Mexico Gas Utility is just a requirement. So I started from that point when I was reading my testimony and developing my positions.
Yeah, and I don't ask this question to sort of delegitimize that. I mean, more the question is, and I understand the value of doing that entirely. But what I would ask is, so for instance, equities as between intra-class subsidization, or which percentage of the base revenue allocation is fair as to which class or another. I mean, that was not your focus. Is that fair to say?
Yeah, fair to say my focus was overall revenue requirement. Is the money being spent in a way that delivers the service that customers expect, while also hopefully addressing the bigger issue, which is climate change.
With regard to the weather normalization adjustment, in the stipulation, paragraph 32, I won't ask you to look on it. It's just a very general question. You'll understand it simply, but the signatories agree that it is appropriate to extend the term of NM Gas Company's pilot program for a weather normalization adjustment mechanism. Why was it appropriate? I know there are answers to this question, but I'm just curious from your perspective, if you agree that it was appropriate, why was it appropriate?
From my point of view, it's appropriate because of this larger context I agreed to. I described earlier that gas companies showed that it's getting warmer. And so in order to provide the service that gas company provides, it's appropriate to have an adjustment that addresses that fact.
Okay. With the memorandum of understanding that you reference at page 8 of your testimony, is there any question about enforceability? I mean, I'll just put the question simply this way. You include reference to this, and I believe it's in the stipulation that there's, I shouldn't say, but what business does the commission have in terms of overseeing memorandums of understandings between parties? So what happens if an understanding changes? Did that have any concern for you?
The memorandum of understanding is an agreement between the signatories of the MOU to have a discussion and work towards a goal. That's a few steps away from doing something like enacting a law that would affect commission rules. So I'm not concerned about commission enforceability of that commitment that we made with the gas company, because I believe that commitment was entered into in good faith, and I expect that gas company will live up to its commitment, and I know that we will.
Okay. Um, That was all my questions for Mr. O'Connell, Ms. Hurst.
Thank you, Hearing Examiner Ryan, and I just have one other question, Mr. O'Connell. And it's similar to Hearing Examiner Ryan's last question, but what I'm actually asking you is that the stipulation, especially in the latter paragraphs that don't have to do with the IMP or revenue requirement, the paragraphs that actually have to do with the greenhouse gas emission initiatives, I believe, is how it's STEM or how it's characterized. Along with those additional provisions that I asked you about earlier. Several of those have agreements to analyze or a particular issue or to cooperate together for future legislation. And these agreements to do these things, whether on the part of gas company or all of the parties, appear to me to be more aspirational than concrete commitments. And I'm just wondering whether or not you believe that there's going to be a way to enforce those.
I suppose if you could give me an example to the contrary to what I'm
Sure.
about to say, because what I saw in the stipulation when we were negotiating it is embedded in each one was a report or a study or something tangible that would be required with the provisions of the stipulation. And memorandum of understanding is more of a commitment to a conversation and a work together. I believe that's outside commission enforcement. That's something I believe that we entered into in good faith with the gas company. But the provisions within the stipulation, I believe, are enforceable because there will be a tangible milestone associated with each one.
Okay, and I'm not talking about the MOU at all. For example, if you look at paragraph 21, you know, it says what it says, and then in the middle it says, in fulfilling commitments made in these paragraphs, the gas company is committed to providing adequate and reliable service, just and reasonable rates. Also commit that any feasibility studies conducted pursuant to those paragraphs, paragraphs 22 through 25, will include a rate impact analysis. So, okay, there's an analysis. Who's going to enforce that and how?
Each one of these cases, like for example, hydrogen blending project, moving to phase 2 will require a hearing in front of the commission. So it will be apparent and a requirement, I would guess, of whatever gas company applies for, that it shows that it did meet the commitments of those paragraphs. So I will hold them accountable, and then they will have to provide the receipts to the commission in future proceedings that would implement or affect revenue requirements or rate design.
Well, yeah, I mean, I understand that, you know, if and when they ever complete phase 1, that they agree, you know, that they're going to come to the commission before starting phase 2. But it's some of the details. Any determination made by New Mexico Gas Company that its phase 1 results prove promising, and any decision by gas company to pursue any further products utilizing hydrogen. I mean, It just seems like to me, like you say, that several of these things are aspirational. 23, when it's talking about electric and hybrid vehicles. An annual comparative analysis of proposed vehicle shall include, and it's got the things it's going to include. This comparative analysis shall be made available to stakeholders for review when feasible. The on-duty cycle and daily mileage, blah, 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 will, company shall show a preference. How are you going to enforce those things, Mr. O'Connell? What if they don't do this comparative analysis? What's
Then that'll
WRA
be-
going to do about it?
What we will do about that is then in their next rate proceeding, pose their request for their vehicle investments.
Okay. Again, if your testimony is that you think each one of these agreements to come together and discuss things, or for gas company to do a particular analysis and share or get your input, if you think if it has a concrete requirement that's transparent and enforceable, then that's your testimony.
Yeah,
Right.
that is my testimony, and the ultimate.
Okay. And go ahead, sir.
I was gonna say the ultimate accountability for gas company will be in a future rate case.
Okay. So you're not asking the commission to do anything to potentially to enforce these paragraphs?
I'm not asking that, no.
Okay. Thank you, sir. Ms. Beatles, or hearing examiner Ryan, anything further?
Oh, thank you.
Thank you. Ms. Beatles, any redirect based on our questions?
I have nothing further. Thank you.
Okay, very well. Does any party have any questions based upon my questions or hearing examiner Ryan's questions to Mr. O'Connell? Okay, hearing none. Mr. O'Connell, you're excused, sir. Thank you.
Thank you.
I believe pursuant to time constraints, the parties have agreed now to hear from Los Alamos County witness Garcia. Mr. Najjar.
Yes, thank you. Is Mr. Garcia's connecting? I see. I'll just wait a second. Okay, I think he's there. Go ahead and let's have Mr. Garcia sworn in.
Hello there, Mr. Garcia.
Morning.
Good morning, Mr. Lee.
Oops.
Mr. Garcia, would you raise your right hand, please? You solemnly swear the testimony you're about to give the matter not opinion should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
Thank you. Yes, would you please state your name and business address for the record?
Yes, my name is Jordan Garcia. We are located at 1000 Central Avenue, Suite 130, Los Alamos, New Mexico, 87544.
And Mr. Garcia, by whom and in what capacity are you employed?
Yes, sir. I'm work for the Incorporated County of Los Alamos Department of Public Utilities, and my title is Deputy Utility Manager of Power Supply.
Mr. Garcia, you have before you a document which has been marked as LAC Exhibit 1. Do you see that?
Yes, it's a copy of my pre-filed direct testimony in this proceeding.
And do you have any corrections or changes to make at this time to LAC Exhibit 1?
No, sir.
And is that a true and correct copy of what was filed in this proceeding?
Yes, sir.
If I were to ask you the same questions today as contained in your direct testimony, LAC Exhibit 1, would your responses be the same?
Yes, sir.
You also have in front of you a document which has been marked as LAC Exhibit 2. Do you see that?
Yes, sir. It's a copy of my supplemental, pre-filed supplemental testimony in this proceeding.
And is that a true and correct copy of what you filed in this proceeding?
Yes, sir.
Do you have any corrections or changes to make to LAC Exhibit 2 at this time?
No, sir.
If I were to ask you the same questions as contained in LAC Exhibit 2, would your responses be the same?
Yes, sir.
And do you adopt LAC Exhibit 1 and LAC Exhibit 2 as your sworn testimony here today?
Yes.
Madam Hearing Examiner, we would move the admission of LAC Exhibits 1 and 2 and make Mr. Garcia subject to cross.
Any objection to what's been identified as Mr. Garcia's pre-filed testimony in support of the stipulation LAC number 1 as verified by him here today? Hearing no objection, LAC Exhibit 1 is admitted. Any objection to what has been identified as LAC Exhibit 2? Mr. Garcia's supplemental testimony as verified by him here today. Hearing no objection, LAC Exhibit 2 is admitted. Good morning, Mr. Garcia.
Good morning, Madam Hearing Examiner, Mr. Hearing Examiner.
I just have a few questions for you, sir. And I just heard you identify yourself as the Deputy Power Systems Manager?
It's the Deputy Utility Manager of Power Supply. When we started this process and filed the original, a direct testimony, I had a different title and I became the Deputy Utility Manager on June 12th.
Well, congratulations.
Thank you.
And sir, what educational or work background do you bring to that position?
Yes, ma'am. I've been employed with the county in the power supply division or handling natural gas supply for the past 10 years and change. I have an MBA from New Mexico State University and a bachelor's from New Mexico State University. And I was originally employed at the laboratory. While obtaining my master's, I worked with some of the people in senior management at the utility, and I was fortunate enough to come over a little over 10 years ago.
So I see that, as you've indicated, prior to coming with the county, you did work for the lab as a financial business analyst too. Is that correct?
Yes, ma'am. Yes, madam.
And so it was at that point that you had, you began your experience with gas company or gas utilities?
Yes, Madam Hearing Examiner. When I began my employment with Los Alamos County, I started dealing with New Mexico Gas Company matters.
And based on your testimony, Mr. Garcia, at page 1, you're describing the county's utility operations and the reason for its intervention in this proceeding. And you indicate, beginning at line 18, that Los Alamos County is a municipal utility providing electric, natural gas, water, and wastewater services to approximately 20,000 people within the boundaries of the county of Los Alamos, and that the service that you utilize with gas company is a transportation service. Is that correct?
That's correct, Your Honor.
And that service is provided to you as set forth on page 2 of your testimony under a sale for resale tariff rate 61, correct?
Correct, Your Honor.
And with the way that that's provided, sir, is is that provided by like pipeline from gas company directly to the facilities there in the county?
Your Honor, not directly to the facilities. What we do is we put in natural gas at a pipeline point that we share with New Mexico Gas Company, and New Mexico Gas Company agrees to let us pull it out at 4 meter points or set meter points. And then we own our distribution system for the county, and we distribute it to the local customers.
Okay. So it's not like it is transmission of gas at a certain volume at a certain time to your facility, correct?
Your Honor, that we deliver on a continuous basis. We make nominations for supply on their system and ensure that it's put into their system. And then we take out relative to what our supply is and what our load, what our constituents are using at the time on a continuous basis.
And does the transmission costs vary depending on the amount or when you actually take it off?
Your Honor, the transportation or transmission costs do not vary. They're part of the rate and set. What varies is the actual cost of the commodity.
But you're not paying for the gas company for the gas, are you?
Correct. We are not paying. We have our own wholesale supply contracts.
Okay. So then it's just a flat rate to be able to pull it off the, as you say, at the 4, I forget how you characterize them, but the 4 delivery points.
Your Honor, that's correct.
And you also indicated in your testimony at lines 12 through 15 on page 2 that the county does not serve the lab, correct?
Your Honor, that is correct. They are not our customer.
Mr. Garcia, on page 3 of your testimony, you are answering the question posed at lines 12 through 13. Please describe the county's role in the development of the stipulation. In lines 15 and 16, you say the county did not take part in the discussion on environmental issues, focusing instead on the revenue requirement negotiation and the ultimate rate design. That's correct, sir?
Your Honor, that is correct.
Did you really, I mean, did you look at all the rate design, or were you primarily focused on the one that applied to you?
Your Honor, we hired consultants out to help us with this endeavor, and they primarily focused on the ones that applied to us. So the revenue requirement as well as the cost allocation for customers.
In your conclusion on page 4, that the county, lines 18, the county believes, well, let me read the whole sentence. While there is a range of proportional class increases, the county believes they are just in the context of a settled proceeding where parties have not had the opportunity to present testimony showing what they believe is the correct allocation of costs between rate classes, and in light of the system-wide increase of 9.68%, correct?
Your Honor, that's correct.
Okay, and what's your basis, sir, for the fact that you think that the ultimate rate design is just?
Your Honor, after speaking with our consultant and mulling over the stipulations, we felt it was appropriate, given, what's going on in the environment. I guess, suffice it to say, we expected some sort of increase. There were some existing interrogatories from our consultants that were suspended in lieu of a stipulation. But other than that, we felt it was reasonable and fair at this point.
Well, for example, in the initial proposal in the application, rate 61 would have had a 26% increase as proposed by the company, wouldn't it have?
Your Honor, I don't remember specifically off the top of my head, but I think you are correct. That sounds about right, ma'am.
And as stipulated by the parties, the increase for rate 61 is 9.73, isn't it?
Yes, Your Honor.
So would you characterize as having a 10% increase versus a 26% increase as being well, I don't want to quantify it. So how would you characterize that?
Your Honor, we felt it was the negotiated settlements were appropriate and that we wanted to take part in them.
Well, I mean, obviously, I would think that you're happy with a 10% increase over a 26% increase, aren't you?
Your Honor, yes, ma'am. That is quite a significant reduction.
Would you say that you hope that you achieved what you had hoped to achieve by becoming an intermediary in the proceeding?
Your Honor, yes, we're happy with the outcome and the stipulation that's been presented.
And I'm just wondering if you could explain your characterization at the bottom of page 4, going on to page 5. And this is still talking about why the county supports the revenue increase. You say the stipulation results in the bulk of gas companies' customers, which take service under residential and small general service tariffs, receiving a base rate increase lower on a proportional basis than the system-wide average increase. What does that mean?
Your Honor, it's to highlight that we ourselves are comprised mostly of residential customers, and we see the need for the residential customer classes, to try to minimize the impact. So that's why we made a note of it and felt it was appropriate to include.
Okay, but the residential and small general tariffs that are applicable to gas company are not the residential and small general service tariffs that the city charges, are they?
Your Honor, we have our own costing mechanism here in the utility. They are not the same. Correct.
How do yours compare with
Your Honor,
gas companies?
Your Honor, I would have to find out from our finance director. She runs some comparisons. I think we're fairly comparable in our rates.
Okay. Does the county have rate cases or raise its rate on a periodic basis, or how do they do that?
Your Honor, we do. We are currently undergoing a rate case right now to assess. We split our wholesale supply side, which would be my group, and then we have a distribution group. But we have a variable cost recovery mechanism for the wholesale and sort of the cost of the energy. And we have a fixed rate for our distribution cost and infrastructure to maintain and keep that. And right now it's set as a per therm rate that we assign to our customers.
And do they also pay like a customer charge?
Your Honor, I believe so. I think so. We pay a fixed access fee.
And the current case, is it to increase rates or decrease rates?
Your Honor, it's to increase.
And will what was, if the commission were to approve the stipulation and the rate design, is what you're doing now going to encompass the increase in rate 61?
Your Honor, yes, our rates would currently encompass this. That's part of the variable rate portion of our gas.
Very well. Thank you, Mr. Garcia. That's all the questions that I had for you. Hearing examiner Ryan, did you have questions for Mr. Garcia?
Yes, thank you.
Go ahead, sir.
Mr. Garcia, how are you?
Doing well. Hearing examiner Ryan, thank you, sir.
Good. So Ms. Hurst asked you about the initial rate increase for rate 61, the sales for resale service. And actually you can find that at Mr. Yardley and MGC exhibit DPY 9. And then you don't need to look at this. It would take time to get there, but it does in fact show the percent change in base revenues for rate 61, which you identified in your testimony would have been a 26% increase. Do you know how that number was determined?
Your Honor, I do not.
When were you aware that was the number? 26% was the proposed increase?
Your Honor, yes, sir.
And I guess I mean, it just sounds like a lot. I don't know if you had the same experience, or did it raise questions, or how did you deal with that? Like, what was the?
So Your Honor, it resulted in us hiring consultants to help us with this rate case and bring in some more expertise.
Okay, so the task was effectively, we need to find out why they want to have a 26% increase, get to the bottom of it, and then try to see if that's valid. Is that the basic chain of thought there?
Your Honor, yes.
Okay. And were you ever, I mean, so I'm not asking you to like quiz you. I really legitimately, do you feel as if you were ever adequately explained how the 26% was calculated?
Your Honor, I think we have a general understanding of what was proposed and why it was proposed. And I think that's where we made the decision that there was some wiggle room and we needed to bring in some more expertise to help us understand. But after the fact and going through the stipulation, we feel we have a much better handle on what's going on with the system. And ultimately, it's fair and reasonable from our perspective.
Okay, so can you expand upon that answer at all and explain sort of what is it you understood which explained why there was such a large increase?
From the most part, it was human capital, management of the infrastructure in general. And again, operating utility, we see quite a bit of that on our side as well. I mean, with what's going on in the environment currently, right, for buying steel and all the different things that are involved with it, inflation. So I guess that's about the general understanding we had of what the drivers were. And, for the revenue requirement, it's a little bit, I guess, more, there's some other items in there that are hard to understand, but those are the ones that we looked at primarily and, wanted to take note of.
Okay, I understand your answer to be that, you looked at the things that you just cited to me, the increases in the operation and maintenance expenses, personnel increased costs. They wanted to hire a whole bunch of different folks. That's sort of its general, that's the application as a total. And I suppose I was wondering whether you had any idea why with rate 61, there was specifically a 26% increase. Was that something you ever discerned?
Your Honor, no, that's part of the rate, the cost allocation model that we hadn't really fully developed. But of course, with the proposed settlement, we felt it was, that was better than pursuing and continuing. So it sort of, I guess, halted our efforts at that point in time.
Okay. And then as Ms. Hurst pointed out, we can see in stipulation exhibit number 2, this is attached with Mr. Shell's testimony, rate 61. At least in that is represented as 9.70% as the percent change based revenues. And I actually had the same question Ms. Hurst did, which was, well, that's a fairly significant departure from the initial application. And I guess I would have the same question for you, Mr. Garcia, is were you ever adequately explained how that significant decrease came about?
Your Honor, I was part of some of the discussions with the mediator and without the mediator and the different parties. But our consultants really took the lead on that and just advised us about, what was rational for us to look at and make those decisions.
Do you know what the rate impact of the 9.7% increase will be to the customers on your system of the increase for rate 61, what that will be?
Your Honor, we haven't done the analysis thoroughly. We think it's roughly between $50,000 to $70,000 annually for our customers.
And what does that come out to, like a per customer? If you can approximate, maybe perhaps you can't, that's fine.
Your Honor, I couldn't do that right now with our current, I'd have to look at our number of meters and things like that. So sorry, I apologize.
No, it's okay. So, but I guess in the end, you're saying that that total number was, you found that acceptable for whatever reason.
Your Honor, yes.
Okay, thank you, Mr. Garcia. That was all the questions I had for you, sir. Ms. Hurst.
Thank you. Mr. Najjar, any redirect for Mr. Garcia?
Yes, thank you, Madam
ahead, sir.
Examiner. Just a couple questions. Mr. Garcia, in addition to the factors you mentioned, did your consultants have serious questions about the allocation of distribution costs to rate 61?
Yes, sir, they did.
Were those questions some of the unresolved issues at the time that you suspended interrogatories to the gas company?
Yes, sir.
Thank you. That's all.
Thank you. Any questions based upon the redirect or hearing examiner Ryan or my questions? Hearing none. Thank you, Mr. Garcia. You are excused.
Thank you, madam.
Very well. Mr. Dome, I believe the next witness is Mr. Shell.
Yes, Madam Examiner. Ma'am, before we get started, I thought I would just run something by you. So we have all of our witnesses ready, and so we can start with we will start with Mr. Shell and then go to Mr. Bullard. and then Mr. Wasseen. So we're in that order, but I just wanted to let you know that Mr. Yardley is available today, and we talked about this on Friday. And we talked about 3 o'clock. He is available at 2 o'clock as well. So we can move him up to 2 o'clock so that you have the time that you might need to ask him questions. I'm just saying, he's available at 2 if we want him. So we can go as far as you want to go with Shell, Bullard, Wasseen, Sanders, and then Yardley will be available at 2 o'clock on for us to take him at your convenience.
Very well. I believe that's probably would be our preference is to, since we're trying to avoid bringing Mr. Yardley, have his testimony bifurcated. If Mr. Yardley is available at 2, I think that would be preferable. Hearing examiner Ryan?
Yeah, that's fine. I mean, so if I'm understanding correctly, would we just, I mean, does that mean we're going to go from Shell to Yardley and then Bullard? I mean, would that make more sense? Just do it that, or I
Yes.
guess we have to see where we are at 2 o'clock, I suppose.
Yes.
Yeah, okay. Yeah, so I guess 2 o'clock, we just start Yardley wherever we are. Is that the concept?
Well, hopefully we'll be finished with witness Shell and
Right.
and have lunch in there too. So
Well, that makes sense then. Yes. I agree.
okay. All right. Go ahead. Thank you, Mr. Domi. Go ahead, sir.
Can we swear the witness, Madam Hearing Examiner?
I have to find the witness.
Oh,
I'm assuming he's.
There he is.
we have.
Oh, there you are.
We have a
Okay.
lazy Susan here that we're using, ma'am. and we have to rotate this computer.
Oh, okay. I was gonna say, Mr. Domi, you've changed.
So ma'am, we use this computer so you can, have a better view of the witness. Otherwise, we had this other
Okay.
view, but he's down there. So we just want him to be front and center.
Very well. Thank you, sir.
I'm
Mr.
off
Lee,
to
would
the
you
side.
swear Mr. Shell?
Sir, would you raise your right hand? You solemnly swear the testimony you're about to give in the matter not opinion should be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Mr. Lee.
Mr. Shell,
Go ahead,
and
Mr.
state-
Domi.
Mr. Shell, state your name and your position for the record, please.
I'm Ryan Shell. I'm the president of New Mexico Gas Company.
Now, Mr. Shell, we have a number of exhibits to introduce through you today, so I will take them in the following order, Madam Hearing Examiner. I'm going to do 1, 2, 3, the testimonies, and then I'm going to skip ahead and pick up 38, and then the erratas 4, 5, 6, and 7. So by the end, you'll have all of his testimonies in, and then the application and schedules, and then the erratas for a complete record of the company's filing. Mr. Shell, do you have in front of you NMGC exhibit number 1?
Yes, I do.
And what is that document?
That is my direct testimony in support of the application.
Was this testimony prepared by you or at your direction?
It was.
Do you have any corrections to this testimony?
I do not.
Is the testimony true and correct?
Yes, it is.
If I asked you these same questions today, would you provide the same answers?
Yes, I would.
Do you have in front of you exhibit number 2?
Yes, it's my testimony in support of the stipulation.
And was this prepared by you or at your direction?
Yes, it was.
Do you have any corrections to this testimony?
I do not.
Is it true and correct?
It is.
If I asked you these same questions on the stand today, would your answers be the same?
Yes.
And then do you have exhibit number 3 in front of you?
Yes, it's it's my excuse me. It's my response to the June 6th bench request.
So this is your testimony in response to the June
Yes.
6th bench request?
Yes, correct.
Was this prepared by you or at your direction?
It was.
Do you have any corrections to this testimony?
I do not.
Is it true and correct?
Yes, it is.
If I asked you these same questions on the stand today, would your answers be the same?
Yes, they would.
Madam Hearing Examiner, I would ask for the admission of exhibits 1, 2, and 3. That is the testimony that Mr. Shell has filed in this case, and that is in the Dropbox.
Any objection to what has been identified as New Mexico Gas Company Exhibit 1, Mr. Shell's direct testimony in support of the application as verified by him here today? Hearing no objection, New Mexico Gas Company Exhibit 1 is admitted. New Mexico Gas Company Exhibit 2, Mr. Shell's direct testimony in support of the stipulation, including the stipulation attached as an exhibit. Hearing no objection, Gas Company Exhibit 2 is admitted. New Mexico Gas Company Exhibit 3 is Mr. Shell's testimony in response to the hearing examiner's June 6th bench request. And hearing no objection, New Mexico Exhibit number 3 is admitted.
Now, Mr.
Go ahead,
Shell,
sir.
Mr. Shell, do you have, I'm handing you exhibit, NMGC Exhibit 38. Do you recognize that document?
Yes, I do.
And what is that document?
This is our original application and schedules for this rate case.
And that was filed on December 13th of 2021, is that correct?
That's correct.
Was this prepared either by you or really at your directions in order to file this rate case?
Yes, it was.
Have you reviewed Exhibit 38 over the course of this case?
Yes, I have.
Do you have any, is that the filing that was made by the company on December 13th?
Yes.
Are there any corrections to this?
There are no corrections to this. I believe there are corrections to some of the original testimony, but that will be put forth by the witnesses.
With that, Your Honor, I would move for the admission of NMGC Exhibit number 38 as the company's application and attached schedules that were filed on December 13th of 2021.
Mr. Dome, it's the application and the schedules, but it's not the testimony that was filed with it, correct?
The testimonies would be one of the schedules, but it does not, but that testimony is not included in this. It's just referred to in this as one of the schedules.
Okay, and is there a reason that since this is, the application was filed with the commission as a pleading to start this case, is there a reason why that we need to have the application in the record?
I don't know that there's a specific reason, Madam Hearing Examiner. We thought it would be convenient for the parties to have that in as an exhibit for purposes of all the other witnesses referring to it and so forth. So I don't know, because you're right, it is in the case already as a filed pleading, but we thought it would be convenient for the parties.
It's just a voluminous material. I'm not necessarily opposed. I would just say to the parties for future reference that, in the past, I've always been happy to take administrative notice of the application filed in the case. However, since you're offering it and there's not any objection, I will go ahead for ease of reference for the parties during questioning incompleteness with no objection, admit Gas Company Exhibit 38. Go ahead, sir.
Mr. Shell, do you have in front of you NMGC exhibit number 4?
Yes, this is an errata submitting Mr. NMGC witness Moran's testimony with corrections, his original direct testimony.
And was this filed at your direction as part of the filing in this case?
Yes.
Do you have in front of you exhibit number 5?
Yes, it is an initial list of corrections which were filed as ordered by the pre-hearing order and per rule.
And this was an errata notice, is that correct?
It was an errata notice.
And was this filed at your direction as part of this case?
Yes, it was.
Exhibit number 6, do you have that in front of you?
Yes, it was an errata filed to provide the exhibits and supporting information related to advertising expenses in this case.
And was that filed at your direction as part of this case?
Yes, it was.
And then exhibit number 7 is, do you have that in front of you?
I do.
And what is that document?
It's the 4th errata where we detailed some additional revenues and expenses in this case.
And was that filed at your direction?
It was.
Then, Your Honor, I would move for the admissions of exhibits 4, 5, 6, and 7, the 4 erratas that were filed that were amendments or revisions to the filing in this case.
I believe, Mr. Dovey, that it's more appropriate for Gas Company Exhibit 4 to be offered with that witness's testimony, since there are modifications to his testimony. So I'm going to hold that one in abeyance.
Thank you.
Exhibit 5 is entitled revisions. And my understanding is that this particular pleading alleged 17.1.3.19C non-material revisions to the application. Is that correct?
Yes, ma'am, that is correct.
I believe I previously made known my disagreement with having revisions and amendments referred to as errata, and that an errata seeks to make a change in something that was incorrect, as opposed to something that actually supplements or modifies. With that clarification and hearing no objection, New Mexico Gas Company Exhibit number 5 is admitted. And New Mexico Gas Company Exhibit 6 is also entitled, excuse me, an errata. And in that particular document, gas company is submitting a schedule H-52, which was inadvertently not included. Is that correct? Mr. Domi?
Yes, it is, ma'am.
So again, with my prior clarifications, that I don't think it's an errata. I think it actually, well, actually that one could be viewed as an errata and not a supplement. Hearing no objection. Gas Company Exhibit 6 is admitted. And then the fourth Gas Company errata filed April 27. I lost it. What is it, Mr. Domi?
Madam Hearing Examiner, that was the fourth errata included the revenue and the revenue from the contract and the expense from the supplemental pay program that we discussed at the pre-hearing conference a few weeks ago.
Okay, yes, that's basically those were modifications, potentially could be considered material changes with regard to subsequent events that had an effect on the revenue requirement, increased revenue requests, and increased revenue sources from a contract that had occurred. I recall those. Again, I don't think it's an errata. I think it is a supplement or a modification. And that being said, and hearing no objection, New Mexico Gas Company Exhibit 7 is admitted. Mr. Domi?
With that, Madam Hearing Examiner, I would tender the witness for cross-examination.
It might feel like cross, Mr. Domi, but it is actually examination by the
I'm
hearing
sorry, Madam Hearing
examiners.
Examiner, I would tender the witness for examination by the hearing examiners.
I'm kidding you, Mr. Domi, but thank you.
You're welcome.
Good morning, Mr. Shaw.
Good morning, Madam Hearing Examiner.
How are you?
Doing well. How are you?
I am fine, thank you. And as president of Gas Company, you're the chief policy witness, aren't you, sir?
That's correct.
And you've been president now for about 7 years.
That's correct.
And your educational and experience background is in accounting. Is that correct, sir?
Yeah, earlier in my career, I was a public accountant, and then even when I got into the utility industry, I had a finance background. Worked mostly in finance positions.
Sir, in looking at your direct testimony at page 7, you're answering the question that was posed back on page 4 about discussing the company's ongoing compliance with its commitment made in the Amera acquisition, correct?
I'm sorry, are you on page 7 or are you on?
Yeah, yeah, but the question started on page 4.
Oh, okay, yes.
And so on page 7, at lines 8, you say, well, line 5, you say the $10 million infrastructure expansion program was established to expand.
I'm sorry, Judge, you broke up. The 10 million?
The $10 million infrastructure expansion program was established to expand service to unserved and underserved communities. And as of the filing of this case, all of the $10 million has been spent or allocated on infrastructure expansion projects. Under this program, the company has been able to provide natural gas service to over 2,100 customers and provide service to over 70 communities or parts of communities, pueblos, neighborhoods that did not have previous natural gas service. That's your testimony, sir?
Yes, it is.
Can you elaborate on that and give the commission some more information about exactly where the company's been able to provide that service?
Certainly, this was a program that was set up when we were purchased by Amera back in 2016. So they agreed to provide funding to several different funds. One was an infrastructure expansion fund. So what interveners in that case wanted to have happen was wanted us to expand natural gas service to particularly the communities where maybe it had previously been uneconomic to spend the money to get gas to those communities. So we embarked over a 5-year period to spend the 10 million. People essentially had to apply for funding. And so that took place over about a 5-year period, I believe. And we have essentially allocated all of that funding. We've either spent it or there's projects in the process of being executed where we are going to spend that. And you had asked where we had spent that money, and it's generally all around the state. So in all our service areas around the state, there was funds being expended.
And just for clarification of the record, could you generally define your service area?
Our service area, we're in nearly every corner of the state, actually. We're one of the largest providers of natural gas in the state of New Mexico. There's a few municipal utilities like in Las Cruces and Las Vegas, I think in Raton. But there's also a small privately owned utility that serves about 40,000 customers down in the southeast part of the state. But generally, our service territory ranges from Farmington all the way down to Alamogordo, and over into the southeast part of the state up to Clayton, and really from Albuquerque north up to Taos. So a very wide area.
Okay. Sir, you are testifying further on page 7 as summarizing the gas company's last rate case, 19-00317. Is that correct?
Yes, that's correct.
And you testify at line 16, well, beginning on line 14, this case was settled, and under that settlement, the company received a revenue increase of 4.5 million effective January 1st, 2021. This increase equated to a 1.4% increase in residential customer rates. That's your testimony, sir?
Yes.
Is that 1.4% for what gas company likes to refer to as the average residential rate customer?
I think you're referring to like an average customer bill, the bill impact. Is that what you're?
Yes, sir.
It indicates here that this is the rates. I think it was the actual rate, cost of service rate, rather than the bill impact.
Because I thought that the increase to the residential rate class was 2.355%.
Yeah, as I'm looking at this, I think you are correct, Madam Hearing Examiner. It says customer rates. I think this is the bill impact. So there was a 1.4% increase in our average customer bill.
Do you have any idea? I know you have approximately 500,000 customers.
Yes, 500,000 rough residential customers. I think when you count all our customers, it's about 540,000.
Okay, so 500 of the 540 would be residential customers?
Roughly, yes, it's around.
Okay. And can you tell me how many of those residential customers would qualify as that typical or average? In my understanding, in the 19-317 case, it was a 50 therm user, but now for purposes of this case, that term is utilized for a 53 therm customer. So I'm just trying to get an idea of how many people or customers are actually at that 50 therm usage category.
You know, I don't know. I don't have a number of customers because that is an average. So we have customers above and below that. And I honestly, without having, I'd have to have someone go check to try to understand who might be close to that 53 because it is an average.
Well, and I'm just trying to figure it out because it seems like the parties like to use that as some kind of important metric, but it's not so important to me if I don't know. I mean, if this only applies to, 3% of your customers, and it doesn't apply toward a bigger group, I don't find it to be as helpful. So to the extent you can quantify that, Mr. Shell, either through yourself or one of the other witnesses, please consider it a bench request, Mr. Domecq, that I'd like to know approximately for, and you don't have to go back to 19-00317, but for purposes of the case, the instant case, I'd like to know when gas company refers to a 4.3% increase for a 50 therm residential, average residential customer, approximately how many people does that actually apply to?
Yes, ma'am, we will get that information for you, ma'am.
Very well. Sir, I'd like to ask you if there's a word missing on page 8. Beginning at line 11. You say in the bullet point, in the last rate case, the company sought limited operations and maintenance or O&M increases, but did seek recovery of significant capital investments. The company was making, is that sentence correct?
I believe it to be correct, yes.
Okay. I thought maybe you meant to say, but did not seek recovery of significant investments.
No, actually, maybe I could spend a minute and explain the sentence. In the last rate case, our O&M expenses they didn't increase much from the prior case. So what I was trying to explain here is that our operating expenses did not go up all that much. So the case was really about recovery of the significant capital investments that we were making.
Thank you. I appreciate that clarification. Sir, on page 9 of your testimony, you're answering the question posed at page 8, discussing operations during COVID pandemic. And you conclude your answer on page 9, line 6. It is currently anticipated that the company will be filing for recovery under the COVID-19 regulatory asset in subsequent cases. Can you tell me exactly what kind of expenses you'll be filing for?
Yeah, during COVID, there were incremental expenses incurred by the company, and there was a commission order to track that. So we've been accumulating that, and our finance department has been accumulating those costs. And at some point in the future, we anticipate that we will include those costs in a regulatory filing or a rate case filing. We haven't to date because, frankly, we're still accumulating those types of costs. So.
Okay. So today you are still accumulating those costs.
Yeah, we're trying to. We just brought people back in the office earlier this year, and so we're getting back to normal. But frankly, since March of 2020, we've been operating in a different environment than we had previously. So really, from March of 2020 till just earlier this year, we had people working from home, and so things are getting back to normal now. So I would say that we're probably wrapping up our tracking of costs related to COVID. And it's anticipated in the next rate case that we will reflect those costs.
And I believe I've seen a reference in someone's testimony, perhaps not yours, but I'd say that as the president, the buck probably stops with you, Mr. Shell. So can you indicate whether or not you'll be filing your next rate case at the end of 2023?
We do long-term planning in the company, and I think the last long-term plan that we put together we were estimating that we'd have to come in for a rate increase effective in January 2025. So yes, that would put us filing a case, I believe, in December of 23. So that was our plans previously. We've obviously settled this case, and we'll have to, upon settling this case, we'll have to reevaluate whether that's still our plans or whether we have to change our plans in light of this settlement.
Change your plans to have a rate increase sooner or later?
That could be sooner or later, but with inflation the way it is, I think the company wanted to reserve its Well, you know, we'll have to evaluate as we move through the next 12 months, whether we need to file sooner than that.
Sir, I wanted to ask you about your testimony at page 14. You're answering the question posed on page 13, discussing the O&M expenses. And where the bullet point is on page 14 at line 10, you say, when it comes to customer service expectations for customer service, the customer experience - New Mexico Gas Company operates in a competitive environment with other utilities and with other businesses that are not utilities. That's your testimony, sir?
I'm sorry, ma'am, you broke up there. I didn't hear the last part of it.
That's your testimony?
Yeah, let me read it here.
Lines 10 through 12 on page 14.
Yes, that's my testimony. Yes.
How is it you're referring to? I mean, gas company is as you've indicated, except for some small enclaves, gas company is the gas company for the whole state, right?
Yes, that's correct.
So how are you in competition if there's no other gas companies? How are you in a competitive environment?
Yeah, I'm using competition in when it comes to customer experience is what I'm referring to there, Madam Hearing Examiner. So as customers deal with, Amazon Prime and do their shopping online and that sort of thing, there's a new expectation in the world today regarding customer service. And so we're subject to that as well. Customers expect, great service from us, and they expect a great online experience, and those sorts of things. So when I was saying we're competing, I was referring to we're competing when it comes to how we reach customers and how we deal with customers. Not that we're competing for business, just that customer expectations are much higher.
Okay. Further on page 16 of your testimony, you're discussing the company's requested return on equity. And your testimony on page 16, beginning on line 6, says the projection going forward is that without the rate relief sought in this case, the company's actual / earned return on equity will decrease to levels well below its authorized rate of return. Is that correct?
Yes.
And my understanding in the last rate case, 19-00317, the stipulated return on equity was 9.375, which is the same stipulated return on equity the parties agreed to in this case. Is that correct?
Yes, ma'am, that's correct.
What was your actual return on equity in 2021?
For 2021, our return on equity was 9.56. Our actual return on equity.
So actually, the company did not earn below its authorized rate of return, did it?
Oh, in 2021, the company earned very near to its authorized ROE. What we're saying is as we move forward with those same rates in 2022, and more importantly in 2023, we're going to earn substantially below our authorized ROE in those years without new rates.
Right, but in 2021, it sounds like you exceeded your return.
We exceeded by, yes, 0.18, I guess.
Okay, didn't you just say your authorized return is 9.375 and you actually earned 9.56?
Yes, that's correct. So we exceeded by 0.185%.
Well, I would think that's a positive for the company.
Yes, we were very happy to earn close to our ROE.
In looking at your testimony, gas company exhibit 2, your testimony in support of the stipulation, Mr. Shaw. The company's initial revenue requirement increase was 40.7, but the parties to the stipulation agreed to an increase of $19.3 million, correct?
Yes, that's correct.
So that's a decrease of $21.4 million,
Yes,
approximately 53% less than your original request.
I have not done the math, but I think you're in the ballpark, yes.
Okay, well, you're the CPA, sir, not me. I like to tell people I have an abacus, and that's about it. So would you characterize that as a approximately 53% decrease?
Yeah, I don't dispute what you're saying. I think you're very close there. I think you're.
Well, do you characterize that as large or significant, or?
It was a significant reduction for us, yes.
But you're happy with it, or you wouldn't have signed off on it, right?
No, we're, this was a settled case, and we worked with interveners through a negotiation process, and ultimately ended up at 19.3 million that everybody could agree to. We wanted to sign the stipulation if we weren't comfortable with the 19.3 million.
And I guess one of the questions that I have, Mr. Shell, from a policy, from your policy position standpoint, is to have you explain to me. I mean, it looks like to me that in the past 4 years, you filed 3 rate cases, right?
We have filed 3 rate cases recently. I'm not sure they're all in 4 years, but yes, in the last five or so years, yes.
Yeah, in you filed case number 18-0038, and that was a rate case, right? And
Yes.
you filed 19-00317, and that was a rate case, right?
Yes,
And you filed 21-00267, and that's our case, right?
that's correct.
And my understanding is that in the 18-0038, there was a stipulated revenue increase of 2.5 million, correct?
That's my recollection, yes.
And in 19-00317, there was a stipulated rate increase of 4.5 million,
Yes,
correct?
that's
And
correct.
then in this case, there's a stipulated revenue requirement increase of 19.3 million, correct?
Yes, that's correct.
So if you added those three up, you would have like $26 million, right?
Yes, close to that, yeah. 2.5,
And
4.5, yes, it'd be about $26 million.
yeah, and I mean, you're paying $1 million, at least $1 million, if not more, per case in rate case expenses, aren't you?
Yeah, I think we are paying $1 million or more per case.
Uh-huh. Don't you think that it might be actually less of a headache and less rate case expense for the company to just like file a rate case and on less than, having 3 and 4 years and incurring all that rate case expense and just have it litigated?
Well, we certainly we had the option to litigate. We felt in this case that we had reached a settlement that was fair, just, and reasonable. So we agreed to settle this case as we did the prior cases. I guess in terms of the, well, I guess, does that answer your question, ma'am?
Well, again, I'm just looking at it, I mean, I'm just looking at the numbers that, you filed 3 rate cases in 4 years. You've probably accumulated at least probably somewhere between $3 and $5 million in rate case expenses for those cases.
Mm-hmm.
And they've all been stipulated. And I'm just wondering if, the company in its long-term planning is potentially looking at whether it might be better off for the company in terms of expenses, rate case expense, and in terms of time and effort and focus of your employees to file rate cases less frequently and maybe not stipulate to something less than what you think you should get. And rather than having these, many small rate cases.
Yeah, no, that is something that we consider all the time, Madam Hearing Examiner. In fact, in this case, we had a pretty significant discussion during settlement negotiations on whether or not we should just move forward with litigation. But ultimately, as you know, when I say litigation, but a contested case, as you know, contested cases are, unpredictable as well. And we really felt that we had reached a settlement that was fair for customers and fair for the company. And so we agreed to sign on to this settlement.
Well, not trying to micromanage Mr. Shell, but again, I mean, 2018 to 2022 is 4 years. Then if you're going to file again in 2023, then you're going to have 4 in 5 years. So do you ever, from a policy perspective, worry about some of these issues? For example, like the IMP issue, which you filed in your last rate case and you withdrew it, and then you file it in this case, the mechanism, and I understand you have still included the IMP regulatory asset, but do you think that there is a potential negative implication if you come in and you ask for something and then you keep withdrawing it, that perhaps maybe you want to have it litigated sometime, Or do you think that if you finally did come in and not withdraw it, that it might be perceived as, well, they must not really need it because they've asked for it in X of the previous rate cases, but they keep withdrawing it.
Yeah, ma'am, I guess when it comes to the IMP mechanism, we do think it's important, and that's why we have put it in all our cases. If we were to actually go to a contested hearing, we would probably either get it or not get it. What we have viewed in the settlements over the last two cases is that we have been able to arrive at something in the middle that seems to work for all parties. But we do run the risk, in a litigated case, that we might lose it completely. So again, when it comes to settlements, you're looking for what's best for the organization and in light of what other parties are arguing for. And we felt that getting something rather than not potentially nothing was a better spot to be in. So that's why we have settled with the regulatory asset treatment in the last two cases. The reality is we would like an IMP mechanism. So we will continue to push for that. But we also know that there are interveners to our case that are not in favor of those. So we felt the regulatory asset was a good outcome for us and for customers, and so did interveners to the case.
Well, I mean, are you just like sort of holding it out there like the sword of Damocles over people's head that it's a bargaining chip?
No, absolutely not. We would like to have the IMP tracking mechanism for our company. There are lots of those types of mechanisms across the country, capital investment mechanisms, and we would like to have one for this organization. We think it's important.
Sir, I'd like you to look at your testimony on page 9. You're answering the question posed at line 9. Please describe what the parties discussed with regard to the energy burden on low-income customers of gas company. And in this memorandum of understanding, which is not part of the stipulation, you agreed to work together to draft legislation in the future. Is that correct?
Yes.
Gas company has also agreed to discuss strategies intended to reduce the energy burden of its low-income customers. Correct?
Yes.
What type of strategies that aren't already be implementing do you envision there to be discussed?
I think that's unknown at this time. I think the point here was we wanted to get together with some of these interveners and have that discussion and potentially propose something for the next legislative session. So we just agreed to work with them on this endeavor. It's something that if the legislative branch here in New Mexico were to look into that, it'd be something that we would be interested in and want to be involved in. So we would do this even if it wasn't with these particular interveners. We would probably be very interested in what any legislative action might be with regard to low income rates.
Do you foresee any potential legal problem with having rates that discriminate potentially in favor of one customer over another?
There may very well be. I'm not an attorney, so I can't answer that as an attorney, but I suspect there will be pushback from various parties in that regard.
just so that I understand your testimony, Mr. Shell, you're actually paraphrasing gas company witness Yardley's testimony at the bottom of page 10. And you say at line 21, the stipulation results in a 9.65 base rate increase to rate 10 residential customers. This is on page 11, line 1, which equates to a 4.3% monthly bill increase for a residential customer with average use. We've already talked about that customer that you're going to quantify. Given that the cost of gas pass-through accounts for approximately 55% of the average residential bill. As a result of the stipulation, the average residential customer will see a $2.67 per month, an increase of $2.67 per month, which is reasonable while providing the company with the revenues needed to continue to operate effectively. Is that correct?
Yes, that's correct.
So basically then in this testimony, you are saying that the cost of gas, which is passed through the by gas company onto the bill to the customer without any increase, correct?
That's right, through our purchase gas adjustment clause.
That's 55% of what the customer's total bill is, right?
Yes.
Okay, and then, so that leaves the 45% of the bill as being New Mexico Gas Company charges for access, transmission, and distribution.
That's right.
And while it might be a 9.65 increase to the residential rate class as stipulated, the overall revenue increase is 9.68, isn't it?
When you're talking about just the cost of service revenues only, and not the cost of gas component, you're correct. It's the residential rate is going up by 9.65%.
No, I said the overall revenue increase is 9.68.
Oh, yes, you're correct.
Okay, and can you generalize, given today's cost of gas outlook, what would you project as a potential increase for the 55% of the customer bill
Well, Madam Hearing Examiner.
this year?
Yeah, if I could make those kinds of projections, I'd probably be have a different job, I guess. It's really hard to know with certainty, Madam Hearing Examiner. I think at least as recent as a couple months ago, I think when we were looking out to the future, we thought gas prices were going to trend down over time. Again, that's just based on forward pricing, but you know, we just don't know. It is a commodity that trades in a market. and it could rise or fall over the next 12 months. It's really hard to know with certainty what the cost of gas is going to do. Could stay the same as well.
Okay, so you can't tell me like over the past 12 months, whether the 55% of the bill that's passed through is increased or decreased or stayed the same?
Oh, I'm sorry. I thought you were asking me to project into the future. If I look back.
I was. This is
Okay.
this is a different question.
Oh, okay.
Based on your answer.
I got you. Over the last 12 months, I mean, gas costs have risen. Especially over the last 24 months, gas costs have risen. I think they've kind of leveled off here recently, but they have gone up pretty substantially from where they were in 2019 and 2020. They've probably doubled. But the 55% is kind of taking that into account. It's not taking into account gas costs from 3 years ago. It's taking into account gas costs here recently, the elevated gas costs.
Sir, I'd like to look at page 12 of your testimony, and you're answering the question at line 4, is the stipulation the result of an arm's length negotiation? And you say yes. As described above, there were significant concessions on the part of the company. How do you define significant, Mr. Shell?
Well, earlier we talked about the fact that there was a reduction from 40 million down to 19.3 million. So in my mind, that's a pretty significant concession to move or reduce our needed revenue request by, as you stated, roughly 53%. So, we're going to have to take steps to reduce some of our capital spending and reduce some of our operating expenses in order to operate within the 19.3 million. So they were pretty significant concessions I would put forth.
Additionally, at the bottom of that page, we are answering the question posed. At line 15 is the stipulation of the public interest. And you're saying, yes, it is, and why. And you say, beginning on line 18, despite this, the company agreed to compromise in order to arrive at the stipulation because the negotiated result provides an increase in rates, which benefits the company and is achieved at a significantly lower cost than would have been incurred in a fully litigated case. Correct?
Yes, I do. I state that.
Didn't I read in the testimony that your projected rate case expenses for a fully litigated case are not decreasing, even though you have a stipulated case?
Yes, I didn't testify to that, but I believe one of our witnesses did testify to that.
So how is your where's the cost savings you're referring to? Significantly lower cost than if it had been a fully litigated case, if the rate case expenses are staying the same.
Yeah, what happened in this case that was a bit different than some of our prior cases is we had some very significant discovery, significantly more discovery than we may have had in our prior cases. So we spent a lot of time and a lot of cost responding to the discovery in this case. And so I think that itself drove up the cost. But I do want to address the fact that if we did litigate the case, they're generally a 2-week case, and oftentimes you have to bring your experts into town and those sorts of things, and they have to carve out a lot of their, they need to carve out time in their schedules to prepare for the case and all of that. So I do think that overall, by settling the case, we are saving expenses. Both the company is probably saving expenses as well as the interveners to the case are probably saving costs as well. So, but the main reason that that our costs are, I believe, in line with what we were projecting is a pretty significant level of discovery that was put forth in this case.
Thank you, Mr. Shell. That's all the questions that I have for you. I believe Hearing Examiner Ryan, you have some questions for Mr. Shell?
I do, yes.
And I'm wondering if it's agreeable with you, since we are close to the 12:30 timeframe, if you would be willing to wait an hour for us to break for lunch from now till 1:30 and come back and ask your questions.
Yes, that'd be fine.
Very well. Why don't we have our luncheon break now? We'll come back at 1:30 and Hearing Examiner Ryan will ask some questions, Mr. Shell. Thank you. Remember, live streaming, if you don't want your lunch live stream, then take corrective action on it. Thank you. We are recessed.
There we go.
Oh, why did it have-
You got it off.
Okay. Okay, I think it is 1:30. And we're continuing with questions for New Mexico Gas Company witness Shell. And I see him. Hearing examiner Ryan.
Okay, Mr. Shell, how are you, sir?
I'm doing great. How are you doing?
Fine, thank you. The 9.375% return on equity that was reached in this case, I imagined in my mind what a commissioner might ask me, and which seems an obvious question. Well, how did they reach that determination, the stipulating parties? And I think on one hand, the answer is, well, that's what the return on equity was from the last rate case, and therefore the status quo has been maintained. And then I could imagine the next question would be, well, how did they reach it in the last rate case? To which I'm obligated to respond, well, that was a black box settlement, and we just don't know the answer to that question. And so I guess I'll just ask it directly: if the commission had a question about how is the 9.375% return on equity appropriate, what kind of comment or what kind of answer could you provide that would satisfy them?
Yeah, certainly. I think we have an expert in this case, witness Morin, who can talk about that later. But just in general, how we agreed upon the 9.375. I think every intervener in the case had experts. I think they probably had a range of what ROEs could potentially be. And it was frankly a negotiation process. There was a lot of back and forth on the ROE. Some people came in initially lower than that. We came in higher than that. It was truly a negotiation. But I think all parties looked at it at the end of the day and said it was reasonable, considering other ROEs that are currently in place across the country for gas utilities.
So then I think what I'm hearing you say is, in some sense, it wasn't merely the product of, well, that's what it was last time.
No, it wasn't.
Okay. In your direct testimony, hearing examiner Hurst went over this a little bit, but I think it's a very important point. So I just wanted to ask a follow-up question as well. So in your direct testimony at 13, you write, with the revenue increase set at 19, I'm sorry, this is direct testimony in support of stipulation. I apologize. So that's NMGC Exhibit 2. So with the revenue increase set at 19.3 million, an average use. Yeah. Page 13. And that's line 2. It's the bullet that's there. And you write, with the revenue increase set at 19.3 million, an average use residential customer will see a 4.3% increase in their monthly bill, assuming gas prices remain unchanged. And then, anyone who's paid attention to current events obviously is aware of this. I wrote a little star there and with the word Russia. And, I think the global geopolitical situation is such, and maybe I'm misspeaking. I don't know. I mean, your comments on this. I guess the basic question is, should we assume gas prices will remain unchanged? And I know you said if you had the answer to that question, you'd have a different job. But on some level, I think what I assume is the case is if gas prices increase, because that represents 55% of the bill, if I'm not mistaken, then in fact consumers are looking at whatever they're looking at in terms of the increase in gas price. And I just want to know, I guess, give you another opportunity to comment on that, because I think it's a very important point.
Yeah, no, you're right. We can't predict where gas prices are going to go. So gas prices could go up, gas prices could go down. What we try to do, and this has been developed over multiple rate cases that we filed over the last 15 years or so. It gets confusing for customers to understand exactly what we're asking for. And we're only asking for a rate increase on a portion of our bill. So when we talk about just that rate increase, so in this case, it's a little over 9%, almost 10%. Customers can get very confused and they think their entire bill is going to go up by 9 or 10%. And what we try to do is make sure the customers understand that, no, this is a portion of your bill. So in relation to your whole bill, it's only going up 4.3%. But you are correct. I can't predict where gas prices are going. If gas prices go up, 10%, then yes, the bill impact. Now you got two components going up 9 or 10%. So the whole bill would go up 9 or 10%.
Yeah, and I'm thinking back to our commenter who appeared. I think she was making very reasonable statements and saying consumers are generally stretched pretty thin as it is. And any increase in prices, I mean, it can't be looked at in isolation. And so I guess I suppose everyone's gambling on some level, huh?
I'm not sure I understood the question.
Well, just in the sense of, you need a rate increase to cover costs. The stipulating parties have agreed that it's reasonable. But, I guess assuming gas prices remain unchanged was a sentence that I thought was fairly significant. And I don't know how much confidence I have in it, frankly, to remain unchanged.
Yeah. And again, we're just trying to help customers understand, and really everybody understand, that the item that we're trying to get approved in this case is a portion of the bill. So we're trying to put that into perspective for people that everything else remaining the same. The customer bill, a residential customer bill, with an average bill would go up about 4.3%.
Yeah, okay, I understand. In one of the submissions that staff supplied, this is a general question, so I don't need to refer to the specific submission. They noted, Mr. Martinez, I'm pretty sure it was, noted in his response to one of my bench requests that the legislature is looking at legislative action on gas-related matters. And I'm not sure exactly what he specifically said, but I wanted to ask you generally, is New Mexico Gas Company working with the legislature about emissions and moving forward?
No, I guess I'd have to go look at Mr. Martinez's testimony. We're not currently working with the legislature on,
if I remember correctly, yeah, I think
related.
what he said was that there was some sort of legislative action which failed to move forward, and I forget at what stage, but you're unfamiliar with that, is what you're saying?
Yeah, I'm unfamiliar with what he might be talking about.
Okay. You note the fact that in the initial application, the gas company requested revenue for 32 different positions, new employees.
Yes.
And as I read the testimony in the direct testimony in support of the application, in many instances, it sounded as if the request was being made for employees whose job it was to maintain safety. They seemed like all very reasonable things to want to have a person doing. And yet now you've retracted all of that. And I suppose the question I had for you was, well, I mean, was that really the best outcome for the ratepayers? I mean, everyone wants a safe and reliable system. I suppose there's varying ways to look at that, I'm sure, but perhaps I'll just ask you to comment upon that fact.
Yeah, thank you. Yeah, no, we absolutely want to make sure we're operating a safe and reliable system. So we had requested 32 positions when we filed the case back in December. I would say today that we still need those positions. However, we've settled this case at 19.3 million. So we want to be able to live within where we settled the case. And another thing that importantly has happened since December is the labor market has shifted pretty significantly here in the state. We saw that happening in March, April, May. And so we've lost more of our base employees. So when we were going through the settlement discussions and talking about whether we could accept or not accept this, the executive team here really took a hard look at where we are today and said, we really need to focus on keeping our current employees. And so we were willing to defer for a short period of time, those 32 positions. So that was how we reconciled this case, was removing the 32 positions from the case. I will tell you that I fully anticipate that we will hire those 32 positions at some point in the future. Some of them we may actually need, sometime in the next 8 to 12 months. And so they are needed in the business, but we felt, given the what you just talked about a few minutes ago, that our customers are facing really kind of unprecedented inflation in household expenses. It just felt like something we could delay for a period of time and help keep our case at 19.3 million. But the reality is we will probably move forward to hire those positions over the next, I'd say, anywhere from 6 to 24 months.
Okay. I asked Mr. O'Connell earlier about the provisions of the stipulation in which the signatories say that they agree it is appropriate to extend the term of the WNA. And I was just asking Mr. O'Connell why was that quote unquote appropriate? It's my understanding that it was a 5-year program. It commenced in 2018, so it was going to run till 2023, right?
I actually think people, I'd have to go back and look at prior cases, but there may have been an opportunity for people to actually contest it. I believe, I'm not 100% on that, but I thought the way it was originally written, it was a 5-year, test period that annually whenever we file our rate cases, that people could choose to contest it at that point. So
okay,
that's why
so
in every case since then, we've asked to continue.
okay. So in effect, I mean, I guess my understanding of what's written there about the WNA, we're putting off any meaningful debate about that until the next rate case. That fight is to come, to the extent to which there is one.
Yeah, I don't know if there'll be a fight or not, but in the next, the 5 years is going to lapse here very soon. So we will be out of the period for the testing of it, and we will propose the actual putting it in place permanently at that point in time.
Okay. And then I figured that the words that follow in that provision in 32 on the stipulation, the provision expressly does not bind any signatory or party from taking any position in any way. It was a clear indication to me that folks were making very clear that whatever the ultimate resolution is, effectively, we're just putting this off for 1 more year.
Yes. Yes.
Okay. This is a question that might be easiest to just share a document with you. And I'm going to pull it up on my screen. I just got to scroll to it. So if you just give me 1 second. Okay, so I'll share. This is your screen 2. So this is stipulation exhibit number 1. Do you see my screen up there?
Yes.
I'm sharing screen. And I was just curious. So I don't want to move it around too much. I'm just trying to zoom in a little bit so we can all see. Why, and I guess here's where I'm here. What we see with this line, the regulatory asset, the IMP, line 110, I'm sort of hovering my cursor over there.
Yes.
The as filed was 198,380. And then in the settlement stipulation, the numbers changed to 157,346, which was a difference of 41,034. I just didn't follow why was there a change with the regulatory asset issue from, I'm assuming that means this is from the 2019 case. And somehow you changed the numbers as to the IMP regulatory asset. And it just struck me like, well, why would that happen? I didn't exactly follow.
So that was from the 2019 case. So it's for IMP construction or investments in 2022. So this year.
Okay.
The This would probably be a better question for Mr. Bullard or maybe even Mr. Buchanan, but I suspect, I'm going to speculate a little bit here, that when we reassessed our capital, that probably some of this work that's being done in 22 was pushed forward a little.
Okay.
As you know, we pushed forward some of our capital. I suspect that that's what happened. So then it changed this estimated regulatory asset a little bit.
Okay.
I think Mr. Bullard or Mr. Buchanan could probably give you a definitive answer on that.
I'll note that. I appreciate it. And I ask only because, it seems like those IMP assets were fairly well earmarked, and I assumed there really shouldn't be too much dynamic kind of fluidity there. So but I'm happy to ask and I understand the response you gave me. And I have just one final question for you, which is also in this. I'll leave my screen share on just because I'm going to get to the document. So I'm just going to scroll through a bunch of stuff here. Just got to zoom out a little bit. I need to be on page 34 of 47. Here we go. So this is, we're looking together here just for the purposes of the record. Stipulation exhibit number 4, page 1 of 2. If you were in the PDF of your exhibit here, it's 49 out of 63. So I see in the way that the rates work, and again, if you want to defer this to another witness, that's fine. But as Ms. Hurst pointed out, you're the principal policy person, but I'll understand if you want to defer this question to another witness. I see, here's your increase in the customer charge, otherwise referred to here as the monthly access fee. It went up a small amount, 40 cents. And then the residential transmission doesn't quite double, but comes close. But the residential distribution doesn't change at all, and then nothing else does as well. And it's actually the same if we go to the next page. This is the small general service, where we see the customer charge goes up, the residential transmission goes up, but this distribution does not change. But why? That's why I'm just trying to figure out is how come all the change comes in the transmission aspect of the bill?
I'm not a rate design expert, so I'd have to defer to our rate design expert, Mr. Yardley, to answer that question.
Okay. Okay, that's fine. I'll be happy to ask him that. That was all the questions I had that Ms. Hurst didn't already go over. Thank you. I'll stop showing my screen.
Mr. Dome, any redirect?
No, ma'am, I
for-
don't have any. No, thank you. No, ma'am.
Very well. Any questions from any party based on my questions or hearing examiner Ryan's questions? No. Okay. Hearing none. Mr. Shell, subject to your participation in getting the answer to bench request 1, you are excused, sir.
Thank you very much.
Thank you.
Madam Hearing Examiner, so we've started to try to gather that information together. I'm not sure when we're going to be able to get it to you. Do you want to give me, do you care when we get that to you?
Well, yes, I do care.
Okay.
But I didn't have a definitive time in mind. Before the close of the hearing would be really good.
Okay, all right, we could do that.
So this week,
Yes, ma'am.
but I think depending, I don't think I'm gonna want to ask questions about it. I
Okay.
just want to know what it is. And I'll probably ask another witness with regard to, again, what the importance of that
Okay.
reference means, but the actual answer itself I want, but like I say, I don't think I have questions.
In my stumbling manner, that's what I meant to ask, was whether you needed it for another witness or not, so I could try to get it to you by then, but I'll get it to you by the end of the week.
Very well. Thank you, sir. And is witness Yardley available yet?
We can reach out to him right now and we'll see if he is. We talked to him, told him 2 o'clock, so he's probably available.
Yes,
Let us-
I see him,
Oh,
I
there
see
you go.
him in the magic waiting room. So let's admit him. Hello there, Mr. Yardley. Hi, you're muted.
Thank you.
Good
Good afternoon.
afternoon.
Yep. How are you?
I'm well. Yourself?
Yes, I'm doing well. Thanks.
Excellent. My name is Elizabeth Hurst. I'm one of the hearing examiners. And thank you for making yourself available earlier. Our goal is to try to not bifurcate your appearance and ask you the questions that we hope you have answers to. So with that, Mr. Domi, why don't you call your witness first and then we'll swear him in.
Madam Hearing Examiner, this is Brian Haverly. I'm going to do this witness. So
Very well.
New Mexico Gas Company calls Daniel Yardley.
Very well. Mr. Lee, would you please swear Mr. Yardley in?
Please raise your right hand, sir. You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, nothing but the truth, so help you God.
Yes, I do.
Thank you.
Thank you, Mr. Lee. Go ahead, Mr. Haverly.
Yes, ma'am. Mr. Yardley, would you please state your full name for the record?
Daniel P. Yardley.
Mr. Yardley, who are you employed by and what is your position?
I am a self-employed consultant to the natural gas industry.
Mr. Yardley, do you have what has been marked as NMGC exhibit number 35 in front of you?
Yes.
What is that?
That's my prepared direct testimony and exhibits filed in New Mexico PRC case number 21-00267-UT.
And was this testimony prepared by you and at your direction?
Yes.
Do you have any changes or corrections you'd like to make to this testimony today, Ms. Yardley?
No.
If I asked you the same questions that are contained in this exhibit, would you provide me the same answers today?
Yes, I would.
Are these answers true and correct to the best of your knowledge?
Yes.
Mr. Yardley, you should also have in front of you what has been marked as NMGC exhibit number 36.
Yes, I have that.
Okay, do you recognize it?
Yes.
What is it?
That's the direct testimony exhibits in support of stipulation of Daniel P. Yardley, filed in the same proceeding on May 31, 2022.
Was this testimony prepared by you and at your direction?
Yes, it was.
Are there any changes or corrections you have to this testimony, Mr. Yardley?
No.
If I asked you the same questions contained in this exhibit, would you provide me the same answers today?
Yes, I would.
Are these answers true and correct to the best of your knowledge?
Yes.
And Mr. Yardley, you have finally what has been marked as NMGC exhibit number 37 in front of you.
Yes,
Do
I
you see
have that. Yes.
Excellent. What is it?
That's questions and answers in response to the bench's June 6, 2022 requests that I'm responsible for.
And is that in the form of testimony, Mr. Yardley?
Yes.
Was that testimony prepared by you and at your direction?
Yes, it was.
Are there any changes or corrections you'd like to make to that exhibit or testimony?
No.
If I asked you the same questions today that are in that exhibit, would you provide me with the same answers?
Yes, I would.
And are those answers true and correct to the best of your knowledge?
Yes.
Madam Hearing Examiner, I would like to move New Mexico Gas Company exhibit number 35, New Mexico Gas Company exhibit number 36, and New Mexico Gas Company exhibit number 37 into evidence.
Thank you, Mr. Howerly. New Mexico Gas Company Exhibit 35. Mr. Yardley's direct testimony as verified by him here today. With no objection, will be admitted. Oh, Mr. Haverly, the exhibits 35, 36, 37 were the exhibits that were dropped into the Dropbox.
Yes, ma'am.
Okay. Therefore, 35 is admitted. New Mexico Gas Company Exhibit 36, Mr. Yardley's direct testimony in support of the stipulation is verified by him here today. And the verification that the copy of that testimony was pursuant to order placed in the Dropbox will, and hearing no objection, will be admitted. New Mexico Gas Company Exhibit 37, Mr. Yardley's testimony in response to the June 6th bench request is verified by him here today, hearing no objection, and having the verification that Exhibit 37 was in fact placed into Dropbox pursuant to order is admitted. Mr. Howerly?
Madam Hearing Examiner, I respectfully tender the witness for questions.
Very well, thank you. Thank you again, Mr. Yardley, for being here today. My notes indicate that you have a Bachelor of Science in Electrical Engineering.
That's correct.
Is that
was-
correct?
Yes, quite a long time ago.
Just a few years ago. And you have 30 years of experience as a consultant in the natural gas industry, analyzing and developing local distribution company and gas pipeline cost allocation, rate design, and tariff mechanisms, correct?
Yes,
But you're not an accountant and you're not an economist.
that's true. I don't pretend to be one of either of those.
No, I find it very interesting that an engineer is doing the rate design and the cost allocations.
Well, if I may, I think that my approach is to take a very practical view of the analysis, and I think that fits well with an engineer rather than a theoretical view that an economist might take. So.
Well, I have a couple of just preliminary questions for you. Were you a witness for gas company in its last rate case number 19-00317?
Yes.
How about in 18-00038?
Yes, although the 2019 case, I testified to the same topics as I did in this current proceeding. In the 2018 case, another witness prepared the fully allocated cost of service study. So the scope of my testimony in the 2018 case was just slightly smaller.
Okay. And I'm looking for an exhibit in this year's in our instant case. One of the comparisons that I noticed, and I want you to explain it to me, there was a nice chart in the 19-00317 case, and it had all of the rates. And in the first column, it said fully allocated cost of service rate of return. And in the second column, it had proposed allocation of revenues. Do you recall doing the chart like that?
Can you tell me what that was labeled as an exhibit to the testimony?
It was labeled as, well, at least the information came from your exhibits 7 and 8 of that particular
Okay.
case.
I just wanted to make sure, yes, there are comparable exhibits with comparable information.
In this,
Yeah,
can
so
you
let me,
identify those?
yeah, I will. So it's going to be an exhibit, NMGC exhibit number 35. And the exhibit attached to that identified as NMGC exhibit DPY 9, page 101, I believe is the exhibit you're looking at.
Let me see if. Hearing examiner Ryan,
Mm-hmm.
can you,
Can we bring that up?
I'd like for you, I want to share my screen.
Do I? You should be co-host. Let me see. Multiple participants can share simultaneously.
Okay. Can you see it?
Here it is.
Yes, I have that.
Okay, so basically this is a chart that hearing examiner Schonauer included in his certification of stipulation.
Okay, I can
And-
help. This is not all from one exhibit, I don't believe, but I can help you with where this information would be in the record.
Right, and so just before we do that, yeah, I see that, you know, the first column is footnoted from DPY 7, and the second column is footnoted from DPY 8. So can you, with that, can you tell me where the comparable information is located in our case?
Yes.
Okay. Go ahead.
I will. I need to find the first column.
Oh,
Gonna
okay.
take me a moment. The second one's easy. The first one it's a little bit deeper into this exhibit. Okay, the first column, the analogous information is found in, again, NMGC exhibit number 35. The exhibit labeled as NMGC exhibit DPY 8. Page 41 and 42. Line 13.
Page 41 and 42 line,
13.
okay. And that is for column 1.
Yes, and to be clear, that line represents the rate of return for each class based upon the company's filed cost of service and the company's proposed allocation of cost of service to the different rate classes as proposed in the initial filing. And that's the same information that's in this column 1. It was from the initial filing. Column 2 is from NMGC exhibit number 35. The attachment labeled as NMGC exhibit DPY9. Column H.
I'm sorry, Mr. Yardley, Elizabeth, Ms. Hurst, if I can, just 1 second, can you repeat which page? I'm on DPY 8, page 41 of 60, is that correct?
That's for the column labeled column 1.
Right, 41 out of 60, and then which column specifically?
So it's
which 9, I suppose.
Yeah, it's transposed. So it's pages 41 and 42, but it's the information horizontally on line 13.
Okay, thank you.
And your examiner, Ryan, did you get the second reference?
Yeah, I did.
Okay.
For column 2, I understood where that was. I just didn't hear the line number.
Okay, so just so that if hearing examiner Ryan and I wanted to make a nice chart like this, what information are we exactly representing? Let's start, for example, with rate 10, the residential rate, and under the first column, if we entitled it fully allocated cost of service rate of return, and in DPY 8, page 41 of 60, at line 13.
The first number for rate 10 in this table would be 7.34%, which is the number indicated at the bottom of the page 41 in column rate 10.
And so for the record, tell us what that 7.34% actually means with regard to rate 10.
Sure. So that's a calculation of the rate of return on investment for the residential class based on the proposed revenues in this case and the proposed costs in this case. Yep.
I'm sorry, sir, go ahead.
Well, I thought it might be helpful to understand the first column on this page where it's the total column. The number at the bottom of line 13 is 6.88%. That's the total revenues that the company proposed in this proceeding, less all of the operating costs. So the revenues are on line 1, less all the operating costs and expenses on lines 2 through 10, generates an income, and that income divided by the rate base. So the income's on line 11, the rate base on line 12 shows you what rate of return is reflected in the exhibit for the total company. It's 6.88%. Each column, as we move from left to right, is essentially a similar income statement for each class that I've generated through various cost allocations so that I have an allocated well, I have a revenue from a class and I can subtract the allocated costs, compare it to the allocated investment, and generate a rate of return for each class, rate of return on investment. And that's instructive to the rate design process.
And could one indicate, could it be said, Mr. Yardley, if there is a positive number in line 13 of DPY 8, page 41 and 42 of 60, if there's a positive percentage, does that mean that that customer class has that the cost to serve that class have been attained?
I'm sorry, attained or retained?
Attained.
Thank you.
If the way I would phrase it is that if that number that you're looking at for that class is above the rate of return that the company is seeking in the case, then the costs are recovered. Because an element of cost of service is not only the operating expenses, but also providing a return on investment. So in this case, the average rate of return, again, in the total company column, line 13, is 6.88%. If every class covered its cost of service, every class would have a 6.88%. But that's not typically what you find. Typically, you find some classes above the average rate of return and some classes below. And that's what we have in this case as well.
So then could it be said that any cost, any rate class who's contributing more than 6.88% in this exhibit is subsidizing the other rate class?
Yes, that's a proper way of looking at it. And that is based on the specific cost allocations underlying a particular study. And people do perform studies in different ways. So based on the study that I performed, this exhibit shows that for instance, rate 10 rate class is providing a rate of return that is just slightly above the average. And so it is providing some degree of subsidy to those classes that are below average. And that did guide my initial rate design. I took that into account, that less of the rate increase should go to residential when we proposed the case. It was based on my study.
Okay. So then, for example, in developing your study and then your ultimate recommendation, the rates that were proposed initially by the company as set forth in the notice. I mean, if you look at, for example, rate 31 in your exhibit DPY8, you have 18.4% return. So that's not quite. It's not quite 3 times more than but at least twice what the average is, correct?
Yes, it's close to 3.
So, but yet, when in your rate design, initially you had proposed a 0% increase for that class, right?
Yes, and we started this discussion by looking at the hearing examiner's memo, I believe, from the last case, which was focused on the rates of
His
return.
decision.
Okay, decision, sorry, thank you. The hearing examiner's initial decision from the last case, that was focused on the proposed rates. What I look at to start with, though, is the rate of return at existing rates before any increase.
Okay,
And
now, and where is that located?
that's what I'm going to tell you. That's the same. That's also in NMGC exhibit DPY 8
Okay,
at pages 21 and 22. Again, looking at line 13.
okay, so DPY 8, page 21 and 22 of 60, looking at line 13, gives the same information as DPY 8, 41 and 42, but 21 and pages 21 and 22 are present rates, and 41 and 42 are proposed test period rates, correct?
That is correct. The reason I wanted to go back and look at 21 and 22 is because I explain in my direct testimony how I took these results. These are a key result from the study, and used them to allocate the revenue increase. So for instance, in exhibit NMGC, exhibit number 35, my initial direct testimony, at page 31, I explained that I took those results and essentially grouped the rate classes into 3 different buckets. And the class that you're focusing on now, the water and sewer pumping, along with irrigation, I grouped those 2 together, and because they were providing the highest rates of return at existing rates, initially, I recommended no increase to those rate classes.
But in the stipulation, that's not the case, correct?
That's correct. In the stipulation, there's a slightly different revenue allocation. And you can see the groupings, as I said, they're explained in my direct testimony at page 31 and continuing. And the groupings are also readily evident on exhibit NMGC exhibit DPY 9, which we've already looked at, in column H. Which contains only 3 different numbers. 0 for rate 30 and 31, 20.5 for rate 10 and rate 54, which was my second grouping, and then 26% for all other classes.
Wouldn't you say that the based upon the groupings that you just testified to, that except for 30, 31, and 35,
I'm sorry, is that 30, 31, and 35?
yes, Mr.
Thank
Lee.
you.
Thank you, sir. I mean, the rest of the increases that you proposed were over 20%, weren't they?
That's true. This is not a bill impact, however. Again, this is based on the company's proposed revenue requirement, which on average, if you're looking still at exhibit NMGC exhibit DPY9, on line 15, the average base revenue increase was 20.8%. That's not a bill impact because it doesn't include gas costs, but that was the average. So the reason that most of them are above is because the majority of customers fall. Well, actually, the reason most of them are above is because of the results of the FACOs. Rate 10 and rate 54 are just slightly under the average of 20.8.
I'm sorry, sir, did you say FACOs?
Yes, FACOs, capital F, capital A, capital C, capital O, capital S.
Thank you.
So, but don't you consider that a 20% increase in percent or 20% change in the majority of the customer classes? Don't you consider that to be significant?
A 20% increase, again, this isn't base rates. So when you look at total bill and you take gas costs into account, it's going to be under 10 for most rate classes. Given the capital investment that is being done in the industry these days, that is not out of the ordinary for other cases I'm involved in. The result of the stipulation, though, is an average base increase that's 9.68%. So on average, which is less than half of what the initial filing was. So the numbers for all customers are much lower.
And I guess, again, I'm just trying to understand, Mr. Yardley. I don't know that you had the opportunity to listen in. I was just asking questions of Mr. Shell. And I think you have acknowledged here that you participated in 3 rate cases within 4-year period of time. Right?
Yeah, I think it may, I'm not exactly sure as to whether it was only 4 years or a little bit more than 4 years, but yes, I've done the last 3 rate cases.
So and I was pointing out that in the 180038, all 3 cases have been stipulated. In the 2018 case, was stipulated for $2.5 million. The 19-00317 was stipulated for $4.5 million. And now this one is being stipulated for $19.3 million. So I think in 4 years, there have been 3 rate cases stipulated to the tune, I believe, of $26 million. And I guess I'm wondering, with how much it costs to do a rate case and all the time and money that's involved, whether or not when the company comes in and wants, for almost all the rate cases, wants over a 20% change in these rates, might it not be more efficient to go ahead and litigate that once rather than doing, potentially multiple short-term solutions.
Would you like me to respond to that?
Yes, sir.
Well, I want to start out by saying that I'm not the revenue requirement witness, or I'm not one of the revenue requirement witnesses in this proceeding. And certainly the revenue requirement witnesses are responsible for their testimony for supporting the overall level of revenues that are appropriate for providing service to customers. That said, I will just from my own experience indicate that I'm involved in a lot of rate cases throughout the industry for LDCs, and that the level of revenue requirements that's appropriate in one year is not going to be sufficient for the level of revenue requirements that are necessary in a subsequent year. This has been particularly true in the industry in recent years, as there have been significant cost pressures that lead to increasing revenue requirements. And so I don't think litigating the 2018 case, in my opinion, would have in any way mitigated the need for a case in 2019, which was, I think, a year and a half later, or this current case.
Do you think that based on your study and your proposed rate changes by class and ultimate rate design, do you think potentially if gas company had held out for a litigated case and potentially gotten more of the $40.7 million it sought, that it potentially could defer having another rate case for a few years?
I really have no way of opining on that without knowing how the cost structure of the utility service might change from one year to the next. So while it does seem logical that had they achieved a higher revenue increase, that might have allowed the company to wait a little longer for a rate case, it's difficult to know. And I will point out that there's no guarantee as to, had they litigated the case, how much revenue they would have achieved. I think one of the benefits of having a stipulated case, as you do here before you, is that the parties are trying to achieve an outcome that is comparable to what you would achieve had you fully litigated the case.
Well, and again, I'm just scratching my head a little bit here, looking at the past two cases and seeing that basically for $7 million in revenue increase in those two cases, I think the rate case expenses were $3 million. Do you recall that?
I don't look at the rate case expense. I will comment on one thing related to the 2018 case that's very important to keep in mind, which is that as a result of the federal tax change, there was a significant reduction in federal income tax expense that offset the revenue increase that would have come out of that case. And so the revenue increase, which I believe you indicated was approximately $2.5 million, was low.
Was stipulated $2.5 million.
Yeah, so the stipulation of $2.5 million also addressed the fact that utility rates were being lowered due to the passage of the federal Tax Cut and Jobs Act. So there was savings that were put through rates at the same time as the rate increase, instead of trying to address the rate impacts of the Tax Cut and Jobs Act separately. But that substantially affected that result in terms of the 2.5 million that you're quoting.
And since you referenced your table, your testimony on pages 35 and 36, and also there's a table 2 on page 36 entitled New Mexico Gas Company fully allocated cost of service rate of return by class. You have each of the rates listed, the rate of return, and then the next column is a unitized rate. Is that correct?
Yes, I have that.
What can you define for the record, sir, what a unitized rate is?
Yes, a unitized rate is the result that you achieve when you divide the rate of return for a particular class in the middle column of that table by the overall rate of return in the middle column on the bottom.
So, Ms. Hurst, could we have a clarification as to which column you and Mr. Yardley are referring to? Are we in the direct testimony? 35?
Yes, we're looking at 35, page 36.
Got you.
Table 2, and it's the last column.
Thank you.
So for example, the unitized rate of return of 1.07 for rate 10 is calculated by taking the rate of return for residential of 7.34% in the middle column and dividing by the overall rate of return in the middle column of 6.88%.
Okay. And I believe, as you have testified before, anything over 1 means that particular rate class is paying for its cost of service.
Yes, it is.
A negative would indicate that it is the particular rate class, according to your study, is not paying for its fully allocated cost of service, correct?
Yes.
And these numbers were based on the present numbers.
This is table 2 on page 36 is actually the numbers at the proposed rate.
Okay, so at pages 41 and 42 of DPY 8.
That is correct. And there's a comparable table on page 30 labeled as table 1, which is the similar information before the rate increase. And the information is from pages 21 and 22 of NMGC exhibit DPY8.
Okay, and this goes back to your, well, this is, you're beginning to summarize on page 29 the results of your cost of service study, correct?
Yes.
And your observations on page 30, beginning at line 3, is that rate 30 and 31 are above the requested return, correct?
Yes.
Rates 10 and 54 are below the requested return, but above the average return, correct?
Yes.
And then group 3, all the rest are below both. Both meaning below the requested return and the average return, correct?
Yes.
Okay. So table 1 is using present rates. Table 2 is using proposed rates.
Correct.
Did you do a table in your exhibit 36 that shows similar information for stipulated rates?
No, I did not. And the reason for that is because as part of the stipulation, the parties did not agree to a FACOS methodology. There are differences of opinion as to allocate costs, but it is possible to allocate the revenue increase as was done in the stipulation and design rates without coming to an agreement on the way to allocate the costs. And so that's the basic framework for the stipulation. It does not contain an agreement on allocated costs, so I did not prepare a similar table.
Could I do it?
No.
I couldn't do
However,
it?
no. And not because you're not an engineer either. What you want to do is use the information from the study that you have in the record to consider the reasonableness of the revenue allocation and rate design in the stipulation. I've done that, which is why I'm comfortable with the way that the revenues are being recovered from customers in the stipulation, even though I don't have a FACOS that directly corresponds to the stipulation. I'm able to use the study that I performed already with an understanding, and it gives me excellent insight on direction and reasonableness of the rates that are being proposed.
So there aren't any numbers that I could use to calculate, for example, a unitized number for each of the rate classes.
No, you're not able to do that, again, because we don't have an agreed upon FACOS. I will say that this occurs over and over again from jurisdiction to jurisdiction when you do have settlements. Typically, the parties don't agree to the cost allocations and do agree to the revenue increase, how it's allocated among classes, and how it's recovered through rates. And it's possible to assess the reasonableness of those based on whatever studies are in the record.
Okay. Sir, if we could look at your direct testimony on page 9. And at page 9 of the gas company exhibit 35, the questions posed at line 12, is it possible to make a high level assessment of gas company's existing rate structure in relation to the goals you describe above? And you answer yes, and I'd like to focus on the part of your answer at lines 22 and 23 that say recently shifting industry fundamentals have led to the adoption of changes throughout the US to resolve the inherent conflicts of a throughput-based rate structure. That's your testimony, sir?
Yes.
Can you explain to me what this means? What are the inherent conflicts of a throughput-based rate structure?
A throughput-based rate structure is when you recover a portion of the fixed cost of service through a variable rate. So for gas LDC service, virtually 100% of the base cost of service or revenue requirements are comprised of fixed costs. A throughput-based rate design recovers those costs through a charge or charges that are based on customer usage in a given month. For New Mexico Gas Company, they have a combination of distribution and transmission charges that I consider to be usage-based. The more customers use, the more revenue the company realizes. The less customers use, the less revenue the company realizes, base revenues. That's a throughput-based rate design. The conflicts that I'm discussing there is that customers are generally better off if they use less gas under that form of rate design, whereas the company is generally better off if customers use more rate design. The fact that that conflict exists has led many jurisdictions to adopt various forms of rate design, such as revenue decoupling, to essentially completely eliminate the difference in interest of the company and its customers. That's what I'm speaking about in those lines of testimony.
And although I realize that the IMP mechanism request is being withdrawn, I would like an answer to the question, and we're continuing on from your testimony on page 9. And in the very last paragraph, answering that question, beginning at line 10 on page 10, you testify why, while no rate structure perfectly meets all of the outlined goals, adoption of an integrity management recovery mechanism as described in the next section of this testimony would further align New Mexico Gas Company with its peers. And my question is, who do you consider to be New Mexico Gas Company's peers?
Gas distribution companies within the United States.
So they don't necessarily have to be in the same geographical area or have the same size system or have the same number of customers?
No, they don't.
Why not?
Well, for purposes of considering an integrity management program mechanism such as was initially proposed, the relevant information is the age of the system, the type of facilities that are still in service in the system, because most gas companies are needing to replace, for instance, cast iron pipe, unprotected steel pipe, or legacy plastic, other legacy steel pipes, because the systems in the United States were built out in many respects over the same decades. It's the fact that those systems have to be replaced now to maintain integrity management that make it appropriate for consideration of this kind of mechanism. And in my view, in talking with the company and those responsible for the operation of the company, New Mexico Gas Company is very similarly situated to the majority of other LDCs in the United States.
Have you done any research, or do you provide any consulting services to water utilities?
No, I do not.
Are you generally familiar with the infrastructure and the age of the infrastructure in water utilities?
No.
Sir, if we can look at page 25 of your testimony, your direct testimony. The question posed at lines 1 and 2, what rates and charges are incorporated into the rate 10 residential rate? And so you start to talk about the two basic rate charges that are intended to cover the non-gas revenue requirements. And you refer to the component of rate 10 consisting of first a monthly access fee and then a flat usage throughput charge. Would you define what a monthly access fee is and what types of costs are being recouped with that fee?
A monthly access fee is a fee that is charged per customer per month. In this case, for rate 10, the current charge is $12 per month. So every residential customer is charged the same charge per month of $12. In terms of what costs are recovered through an access fee, one of the things that the FACO study does is looks at costs that are associated with providing a customer with access to the system and active status on the system, regardless of whether they consume any gas or not. So for instance, even if a customer doesn't consume gas, in order to be a customer, the company has to run a main in close proximity to the location, has to run a service meter, has to be prepared to read the meter, it has to be prepared to issue bills, it has to be prepared to answer the call center. All those types of costs are considered customer related and are typically recovered through a charge such as the access charge. That said, the access charges do not exactly match the costs that I would consider to be customer related. For the New Mexico Gas Company FACOs that I performed, the customer related costs are well above the $12 per month. So we're recovering a good proportion of it through the access fee, but not all of it. The rest of it is recovered through the distribution and transmission fees.
The rest
of the customer related costs are going to be recovered through a non-monthly fixed charge.
Okay. And when you define a flat usage or throughput charge, is the is the volumetric charge, would you define it as a usage charge?
Yes,
But you're saying it doesn't just recover, for example, a distribution or a transmission cost, but in the case of New Mexico Gas Company, it's also recovering some customer related costs that might normally be placed in an access fee?
yes, that's essentially what I'm saying. That a portion, yep.
Go ahead, sir.
I was going to say a portion of the distribution costs are really divided into customer-related distribution costs and demand-related distribution costs. It's a little technical, but I did want to make that distinction. And you are recovering a portion of the customer-related costs through a variable charge, and you're also recovering the demand-related costs through a variable charge. And in this case, at the present rates, the variable distribution charge is 16.61 cents per therm.
And could that also be said for the transmission rate? The transmission service?
Yeah, the transmission rate is also a throughput-based or variable rate that is intended to recover transmission-related costs, which are also fixed. But those would be costs that are associated with compressor stations on the system or large diameter mains. So I don't consider those to be customer costs per se.
But are there any of the leftover access customer related charges going into that? Into the transmission service rate?
There could be. In my mind, on the New Mexico Gas Company system and their rate structure, there's not necessarily a significant distinction between the transmission charge and the distribution charge. Both are variable charges. In many jurisdictions for distribution companies, you only have one variable charge. They happen to have two.
Is it typical for local distribution companies to not collect all the customer charges in the access fee?
Yes, that's pretty typical based on the studies I perform. Usually not all of the customer costs are recovered through an access fee or comparable fee per month per customer.
Why do you think that is?
Well, there's several reasons. One is that you typically find consumer advocates preferring to keep those per customer per month charges down to the extent they can. And the second reason I'll say really dates back to the build out of the gas system in the 50s and 60s, when you really had customers using more gas for more appliances. And so the companies generally benefited from revenue growth by having a lower customer charge as well. And that's just not the case anymore.
Why? Because it doesn't attract?
Well, because we've moved from a situation where individual customers are or were adding gas service for different end uses in their home to a situation where the penetration in individual appliances is more mature. And now we're having older appliances being replaced with newer ones. And so the average use of customers, certainly over the last 2 decades, has been very gradually trending down.
Sir, if we could move to page 37 of your testimony, you're discussing compressor fuel rates
I have that.
and you testify at line 12, gas supplies produced in the Permian Basin require compression in connection with the gathering and transportation to processing facilities, correct?
Yes.
Can you explain a little bit more, since you are an engineer, how this works?
Well, I do feel I need to preface my comments with that I'm an electrical engineer.
Oh, that's true. but-
However, yes, however, the situation that we have here is that when gas is first extracted from the ground, it does not meet quality standards that have been developed in the industry for transporting on interstate pipelines. The gas needs to be processed in various ways and certain elements removed. And so typically the gas that's coming out of the ground will first need to make its way to a processing facility before it can make its way into the interstate transmission system.
So when you're talking about needing this compressor fuel rate, is this just a transportation service, or?
The way I consider it an end use, the end use in this case is you to the extent you're using a gas compressor to move the gas, you need a natural gas supply for the compression. And you could use the natural gas that you're taking out of the ground for that purpose, but it's my understanding that most producers would rather use a pipeline quality gas for the compression fuel that's necessary to move the gas that they're pulling out of the ground. And that's essentially what gave rise to this new rate. It's an end use, just like you would use natural gas to create fertilizer or to heat your home. But it's kind of a unique end use in that it has its own load profile, which makes it appropriate for its own rate schedule.
Sir, if we can look at your testimony in support of the stipulation. I believe it's Gas Company Exhibit 36.
I have that.
Okay, and if you go to page 4, the question posed at lines 5 and 6, why is the proposed allocation of the revenue increase to rate classes reasonable? And you say at line 7, the increases to individual rate classes all fall within 5% of the average increase. That's your testimony, sir?
Yes.
Why is that classification important to you? Or characterization, I guess.
Well, when I was answering this question, I was aware that the different parties to the stipulation had different views about what was the appropriate allocation of costs. We have the company study, but other parties tend to feel differently about some of the assumptions in the company study. And so what I was looking at when I'm considering the reasonableness of the final revenue allocation is that there is some form of sharing of the revenue increase that could be supported by different allocated studies. In my mind, when you have an average increase of 9.68%, if the smallest increase is a 5% increase, which is true for rate 31, and the largest increase is a 13.01% increase, which is true for rate 37. All of these percentages being for base revenues only, not gas costs or total bill. That indicates to me that the revenue increase to each class and the way it's spread is one that moderates the views of different parties with respect to cost allocations. And so, in my view, it's a reasonable one.
Would it have been reasonable if it had been 10%?
Okay, now I'm not commenting on the line 15. If you're looking with me at exhibit or NMGC exhibit DP1 stipulation, page 101.
Well, I'll go look at that.
I want to make sure that we don't talk across each other on percentages.
No, and I could have said 7 or I could have said 15.
Sure.
I'm not looking at any actual, I just want to know if it had been a different number, if it still would have been reasonable to you.
A different number for each class or a different number overall. That's where I was wanted to make sure I was tracking.
Well, it seemed to be, I took your testimony to me that, hey, we have, they range from 5 to 13. And the fact that the lowest to the highest are all within 5% of the average means something to me. And you just testified when I asked you, okay, what did it mean? What did it mean? And you said, well, to me, that was a way to view it as being reasonable, correct?
Yes, and I also tried to use the word moderate. That, in my view, it reflected it. An outcome like that indicates that an extreme view of cost allocation was not relied upon to generate an unreasonable view of how the revenue increase should be allocated. That can occur in some cases when you look at again, in my view, when different parties file studies, sometimes their positions can be rather extreme. I believe that the revenue allocation that's the outcome of this case is not indicative of any form of an extreme view underlying cost allocation, that this revenue allocation can be reasonably supported by the company study or other reasonable studies. Now, I didn't actually indicate that in my testimony at page 4, but perhaps it would have been helpful to indicate that the revenue allocation on that exhibit in column E, the numbers, the individual numbers.
Can you tell me again which one we're looking at now?
Yes. So if I look at NMGC exhibit DPY1 stipulation,
Okay,
page 1 of 1, the testimony that you're asking me about on page 4 is really commenting on column E.
okay. Now I'm looking at the stipulation cost of service reconciliation.
That exhibit was not prepared by myself, and I'm not familiar with it.
Okay. All right. So I want to look at your exhibit.
Which
Okay,
is
I'm there.
also, okay, you're there, okay. And this exhibit I'm referring to is also the exact same as stipulation exhibit number 2, which may have been where you were close to.
Yeah, that's where I was trying to go.
Yeah, the numbers are the same. The numbers are the same. So, but since we're talking about my testimony, exhibit number 36, it might just be easy to stick in the exhibits in there for me. So the testimony on page 4 is commenting on column E of NMGC exhibit DPY1 stipulation, which is comparable to an exhibit that you were focusing on appropriately in the direct case. It's an important exhibit and an important column, the revenue increase to each class. And what I was about to say was that while I didn't say this on page 4 of my exhibit number 36, the testimony in support of stipulation, I could have also indicated that, in my view, column E and the specific numbers, percentage increases to the different classes, are not only moderate among the classes, but also reasonably consistent with the FACOS I supported, or what might be reasonable alternatives to the FACOS that I supported, that I have seen supported by parties in other jurisdictions.
Okay, too many ands on that one.
And perhaps, and perhaps an example would be helpful.
Yes, sir.
So, for instance, on exhibit NMGC exhibit DPY1 stipulation, if you look at lines, thank you, line 3 for rate 30 irrigation service, and 4 for rate 31 water and sewer pumping service, those two classes are getting the smallest percentage increase of all the classes. Those same two classes comprised my group 1, which my analysis indicated should receive the lowest increase. That gives me a degree of comfort in these numbers. And it's certainly reasonable for parties to look at, my study and have some different thoughts. One thought is, okay, if we're providing a 9.68% overall increase in base rates, everybody should pay a little bit at least. And so 0, maybe they didn't want to agree to my proposal to have rate 30 and 31 receive a 0% increase. So when I look at this and I see those two classes are receiving the lowest percentage increase, that seems appropriate. Again, maybe I should have explained a little more on page 4 about that.
Do your other two group observations hold true also?
Not entirely, but it's pretty close. What you'll see is, my second group was comprised of rate 10 and rate 54. I had proposed an increase to those two classes that was just slightly below the average increase. And you'll see when you look at what the parties agreed to in the stipulation, that is true for rate 10. It's slightly below the average increase, but not true for rate 54. Rate 54 is, under the proposal, receiving the average increase. That's a minor difference between what I had proposed for group 2 and what's reflected in the stipulation. So again, I find the proposed increases for those two classes to be reasonable and reasonably consistent with a FACOS, if we had one corresponding to the stipulation.
Okay. Sir, if we could look at page 6 of your stipulation testimony. And the question posed at lines 18 and 19, does the IMP regulatory asset differ from the IMP mechanism? And you testify at lines 20 through 23, the IMP regulatory asset does not provide for timely recovery of costs incurred because it depends on the filing of a future base rate case to reflect costs. In addition, the stipulation does not provide certainty that the prudently incurred costs are recoverable in the future. Why do you think that, sir? Is there anything to lead you to believe that the commission has disallowed prudently incurred costs to gas company in the past 3 or more rate cases that you're familiar with?
No, and when I'm testifying in this portion of my testimony about timely recovery of costs, one of the things to keep in mind is that there is the need to recover the utility's cost of capital on its investment. And we're talking about incremental investments that are going to occur after the end of the future test year. My statement is based on my reading of the stipulation at page 5 in paragraph 18A, where it states in part, the IMP regulatory asset will provide for the deferral and possible recovery of certain costs associated with new IMP projects booked to plant in service after December 31, 2023. So I think it's a plain reading of that language that the company is not guaranteed that it will be able to recover those costs of capital that it incurs between the end of the future test year in this case and the effective date of rates in the subsequent case.
Well, gas company agreed to a regulatory asset in the last case, right?
Yes.
And were any of those costs included in the revenue requirement of this case?
I am aware that the initial filing included the costs, an amortization of the costs included in the IMP regulatory asset from the prior stipulation in this case. I am not certain as to how that regulatory asset was resolved in the stipulation.
You also talk about the timely recovery aspect of is dependent on the filing of future rate cases. Is that correct?
In my testimony in support of the current stipulation?
Yes, sir. The
Yes,
testimony we're talking about.
Yes,
on
yes, I
page
do.
6.
Yes.
Well, don't you think that gas company has some responsibility as far as timely recovery when they agree to withdraw the mechanism, when they agree to a stay out provision, that rates wouldn't go into effect until January 1st of 2023. So don't you think they have some responsibility in the timing, since they're the ones that file the rate cases?
Say stay out provisions.
Yes, sir.
Thank you.
Uh-huh.
Yes, certainly I have every reason to believe that when NMGC agreed to the stipulation as a package, that it took into account its need to recover its costs, including its costs for integrity management that we're talking about right here. And that it believes that the provisions of the stipulation as a package enable it to do so.
Do you know if there's any difference between the terms and conditions or agreements regarding the IMP regulatory asset that were agreed to in the last rate case as compared to the terms and conditions that relate to the IMP regulatory asset in this case?
I would need to perform a comparison of the language in the prior stipulation to answer that with certainty. I believe the general structure of the language is similar. The items that are included in terms of eligible investments may be somewhat different. And I don't believe, although I'm not certain, I don't believe that the prior, the stipulation for the 2019 case had language that was similar to paragraph 19 of the stipulation in this case, but I'm working off of memory.
Okay.
Because I did not review that stipulation. I have not reviewed it recently. So I think there may be some nuanced differences in language from that case to this case. But I think the language differences probably would be evident if the stipulations were pulled up side by side.
Okay. And I have one question, hearing examiner Ryan, if you will allow me. I have one question about your bench request.
Sure.
New Mexico Gas Company Exhibit 37 that you responded to Mr. Yardley. And I'm looking at page 8, where you're responding to question 57. Is gas company aware of any jurisdictions that have rejected infrastructure cost recovery mechanisms? And you testify at lines 19 through 22 of page 8 of Exhibit 37. I am not aware of a state utility commission decision in a litigated proceeding that has resulted in the rejection of an infrastructure cost recovery mechanism for integrity management costs. That's your testimony?
Yes, it is.
Are you in a position to be aware of if there was one?
It's possible that there would be one that I wasn't aware of. However, I've followed this issue in the industry fairly closely. So the vast majority of cases, to the extent there's been a litigated case, the mechanism has been approved.
So this is a particular topic that you keep apprised of, Mr. Yardley, not just in here in New Mexico for gas company.
Yes, that's the case. I've worked with several LDCs again across the country on this issue, developing mechanisms, working directly with stakeholders to make changes as necessary, to get mechanisms that have gone into place. And as well, there was an exhibit which bench request 58 asked me about, where I provided information in my direct testimony as what should be indicated as NMGC exhibit DPY5 that shows the vast majority of gas distribution companies in the US do have mechanisms that are similar to the one that was proposed initially by the company.
Do you think that fact of your testimony that there hasn't been a rejection in a litigated proceeding for an infrastructure cost recovery mechanism should give gas companies some comfort when they made this request that it would be approved?
Well, for starters, I'll point out that I advised the company very closely on what was appropriate to propose in this proceeding with respect to the integrity management program rate mechanism. My proposal reflects the fact that, again, the nature of the problem is similar for LDCs essentially across the country, as we had discussed earlier, that the age of the system, the fact that cast iron, unprotected steel, legacy plastic pipe are still in service and need to be replaced, is true for New Mexico Gas Company as it is for the vast majority of other LDCs, and that other LDCs and their stakeholders have found that establishing a separate mechanism to recover these costs is often the preferred approach because it's more efficient from a regulatory perspective and typically provides more oversight and ongoing communication between the utility regulators and other stakeholders as to how to conduct that process. And that's why I did believe it was appropriate for the company to propose such a mechanism. But again, the company and the parties to stipulation chose a somewhat different direction on this issue.
How much of a difference do you think there is between allowing the integrity management plan mechanism and having a rate case every 2 years? Do you think there's a significant difference in the time recovery between those two things?
Well, certainly if you're having frequent rate cases, that substantially reduces the regulatory lag that would otherwise exist when you don't have a mechanism.
I know that was more than one question on those bench requests, so I'll stop. Thank you. Mr. Yardley, that's the questions I had for you. I would propose, since it is looks like it's 20:25 after 3, I would propose we take a 10-minute recess and then come back with questions that Mr. Ryan has for Mr. Yardley. So we'll come back at 25 till and after our brief recess. think we're back from our recess, and hearing the examiner, Ryan, you have questions for Mr. Yardley, sir.
Okay, thank you. Mr. Yardley, how are you?
Good to be with you.
Very good. So starting with your direct testimony, that's NMGC 35 at page 4. The first bullet there, I went and read the testimony in the 19-00317 case, and I think this actually appears in exactly the same form in that testimony as well. And so I guess the reason I brought that up is just to ask, is the structure you're describing here that NMGC exists with, where you say NMGC's current base rate structures for most classes recover a substantial proportion of fixed costs through variable charges, and then you describe that in some detail. Is that typical in the gas industry, or is that unique in some way to the New Mexico Gas Company?
It is not unique to New Mexico Gas Company. Many other LDCs are similar. However, a small number have gone to a rate design that has no usage-based charge and has more of a flat fixed charge, but that's certainly the minority. Most are like New Mexico Gas Company.
Okay. And I guess a substantial portion of fixed costs through variable charges. You talked about this to some extent with Hearing Examiner Hurst. I mean, it gives rise to the decoupling question and policy issues related to efficiency and what does a company do when they're in that circumstance if their revenue is predicated upon volumetric sales. Is that a problem for the gas industry generally when emissions considerations are driving much of the discussion these days?
Certainly, the issue is common among gas companies and their stakeholders, and how to best promote energy efficiency, for instance. Many jurisdictions have moved towards revenue decoupling, which you mentioned, as a solution. New Mexico Gas Company did not propose revenue decoupling in this case or a prior case, but it's certainly something that could be appropriate for the gas company at some time in the future.
I mean, I guess I'm trying to understand how does the gas industry position itself most effectively? I mean, obviously this is this rate case, so I know I'm asking sort of a macro question, but you know, when I asked the question, is emissions controls, you know, specifically CO2 emissions, a consideration for rate design, and you answered no. I mean, I guess I can understand why the answer is no, but perhaps other policymakers aren't going to be satisfied with that decision or that sort of answer. And what is it that the gas companies do in terms of rate design moving forward to build that in as a consideration?
Sure, and the reason I answered no is because I don't consider rate design to be the driver of effectuating or determining policy. And if you look at, for instance, even the 50 states, right now, they are taking divergent paths on how to deal with issues related to reduction in CO2 and other emissions. Some are fairly aggressive. Some are more in a wait and see mode. And so it's best if the policymakers, together with stakeholders, including gas companies, work together to come up with the general direction they want to go, and then try to make sure that the rate design doesn't get in the way of that direction. And I just don't see rate design as the leading approach necessarily to accomplish whatever the policy goals might be.
Okay. At pages 10 and 11 of your direct testimony, you're discussing integrity management program cost recovery mechanisms, and you identify in the bulleted list there at the top of 11 the type of costs that are incurred by a company to deal with what are generally integrity management program costs. And you say there at line 7 to 8, the associated costs of these bulleted items are necessary to maintain safe and reliable service, yet there are no incremental revenues associated with these integrity management activities. And I'm just trying to understand how that could be the case. And perhaps I just need to have a better understanding of what, incremental revenues are. But how, for instance, could ensuring things like you're not cross-boring into a sewer, which can lead to sort of catastrophe when you're laying gas pipe or whatever, how could there be no incremental revenues for that type of thing? I know I'm asking maybe perhaps a very general question, but I want to understand to make sure that I do.
No, I think there's the potential to probably clarify this testimony a little bit. So I think this is a good point of discussion. The list, which begins on items 10, page 10, and continues on to page 11, is reflective of the New Mexico Gas Company specific integrity management plan and the investments that they need to make to address potential issues on their system. And this list of 8 items are items that they need to make investments in as under their plan. And when I say that they don't produce incremental revenues, what I'm stating is that they don't produce incremental revenues separate from a base rate case. There's a common distinction in the industry that's made between capital investments that are growth oriented and capital investments that are replacement oriented. Growth oriented investments might be main to a new area. You put in new services, new meters, and you attach customers. That capital investment generates new revenues that help to offset those capital investments, and you don't need a base rate case to achieve those incremental revenues. The distinction I'm making here with respect to this list of 10 or 8 items and integrity management investments that are just replacing facilities that are already there, that there's no new customer revenue component that comes about. The company certainly can file a base rate case to recover the costs that they're incurring. There's no prohibition against that. But the distinction I was making was just between the type of investment that has customer growth and customer revenues to help support it, and this type of investment which has none.
Okay. And so then I think I've understood what you just said. And so I guess is that where sort of the timing consideration comes in and why a company would prefer the mechanism versus having to wait for a rate case, because I guess you're getting it much quicker. I mean, that's the basic.
You're getting it much quicker, yes, but also it's a known activity that you need to engage in as soon as you finish one rate case. Now, in this case, we have a future test year, so the costs associated with these activities through the end of 2023, which is a future test year, are to be included in rates. But beyond that time frame, you have to do this activity. It becomes a drag on your ability to recover your allowed rate of return by virtue of these ongoing capital investments without having revenues coming from customers, again, absent filing a new rate case at some point in the future.
Okay. I'm pretty confident I follow you. And I guess this gets into a question I had about the NARUC policy paper that you submitted as DPY-4. There was a paragraph in there. It's page 8 of 10. And the way they characterize it sort of confused me. And maybe perhaps you can help me understand better. And they say, while upgrades to existing.
sorry.
Yeah, you want me, if you want to
Sorry
get
interrupt
there.
you. Can
Yeah,
you
it's
just give me the page reference again and I'll make sure I'm
Sure.
with you.
So this is, again, this is just for the record, NMGC Exhibit 35. This is your direct testimony. And then it's Daniel P. Yardley 4. And then it's page 8 of 10 of Exhibit 4. And it's that paragraph that begins for an LDC, and then about halfway through, there's this sentence that begins with, while upgrades to existing infrastructure are useful, these investments do not create infrastructure that is used, making them unlikely to be allowed by the regulator as part of rate base. And I saw that and I was like, that doesn't make any sense. How is a section of pipe that has been replaced with something that's safer and more secure, or has less capacity for leaking or whatever, not used? Just the way that sentence is constructed, I didn't understand.
Yeah, I think you didn't understand it because I don't think that's an appropriate way of characterizing these type of investments. Certainly, when you replace a piece of the system, whatever it is, a piece of main that needs to be replaced, or a service, as soon as you replace it with the new investment, it's being used. So
right.
I'm not really sure why they would have characterized it that way. And sometimes that's what happens when you have group writing, in a document. So I certainly think you're focusing on that sentence appropriately. It doesn't make sense in the context of what we're discussing.
And I guess what I understood from you is that the problem, it seems, is even if you have a future test year case, as we are now, and you could project outward, you can capture so much of the IMP type costs, but you're going to have to keep doing them because it's going to take time to do it all. And if your point is, well, then you're going to have to keep coming back to the till, if you will, right? The company just has to keep coming back to say, hey, we're doing more IMP programs and we're back again and we need the money because here's another. Is that the kind of problem that you're alluding toward?
It is, and I think it's unique because it's a discrete, knowable type of problem that you can examine independent of other things. Other types of costs, sometimes it's appropriate to consider all of the utilities costs at once in a rate case. But this type of cost, I definitely believe is appropriate and possible to do discreetly on its own, which then lends itself to the type of mechanism that I had initially proposed.
Okay, thank you. That was very useful. I understand that much better. Chart at your direct testimony. This is at page 30. The FACOS return, rate of return by class. I believe I understand what these, I had the same questions hearing examiner Hurst did, and trying to understand the idea of unitized and the FACOS rate of return you have here. And again, this chart we're looking at in table 1 is before the rate increases. So at present rates effectively, is that correct?
That's correct.
And then the one that we see subsequently is with the proposed increases.
That's correct. As the increases initially proposed by the company.
Yeah. And for purposes of present discussion on table 1 here, and I just want to, again, I don't want to belabor it too much, but the overall return is 2.24%. And so that tells us that the rate of 10 residential fully allocated cost of service rate of return at present is 2.31. So they're earning slightly higher than the average.
That's correct.
And then, but that's just telling us based on, I guess, what the 2.24 overall tells us under present rates, this is what the company should be earning. Or I guess maybe, can you explain what is the overall number, 2.24?
The overall number is generated by taking at present rates, the revenues that are realized by the company for the future test year, less the expenses for the future test year.
Okay.
and then divided by the rate base for the future test year for the company in total produces a 2.24% rate of return.
I see.
And that can be calculated on the A schedules as part of the filing. The FACOS model is not necessary to calculate that. However, it's a point of reference for me, and so it's calculated on the FACOS and shown in this table as well.
Okay. And so if I understood correctly, if under the present, so this relates to the future test year. So that 2.24%, I mean, under the future test year, the return that you're seeking is much higher than 2.24%, right? The company wants, that's correct?
Correct. That's it. That's the difference between the requested return and the return that's shown.
Yeah.
When it's adjusted for income taxes gives rise to the initial proposed revenue increase of, I think it was 40.9 million.
Right. Okay. Okay. This is a question I asked Mr. Shell to answer, and maybe he actually directed me to ask you this question. So I'm going to share my screen here. You can see I'm looking at, this is New Mexico Gas Company exhibit Ryan A. Shell 1 in his stipulation testimony. Stipulation exhibit number 4. Page 1 of 2, and my question relates to these figures here, and it occurs to me that the only numbers that change in this entire sort of this rate, which is rate 10, correct? I'm looking at.
Yes, you're looking at rate 10.
This is the transmission charge. I mean, the customer charge changes, and then the residential transmission charge changes, but then the residential distribution and everything thereafter stays the same. And that repeats when you go look at the, I believe this is the small volume general service bill. Again, it's just the service charge and the transmission charge. So why doesn't the distribution charge change is my basic question.
The reason I didn't propose a change to the distribution charge was because within the FACOS model, that I performed, I looked at costs that are functionalized as distribution and compared them to the distribution revenues at existing rates. And the distribution revenues in that case are the combination of the access fee and the distribution charge. I performed a similar comparison for the transmission functionalized costs in the FACOS, comparing those costs to the one charge of the transmission charge. And when I did that, I determined that the distribution revenues were somewhat above the distribution costs, whereas the transmission revenues were somewhat below. So when I made decisions as to how to recover the increase, I first looked at the access charge, proposed an increase to that in my testimony. Same thing was done by the parties in this case. And then the question is, where does the rest of the increase come from? Because of the results of the FACOS that I just described, it was most appropriate to put the rest of the increase on the transmission charge. Again, customers pay both charges based on their usage. So it's a little bit of a nuance. It's not a significant decision, but one that, in my view, is appropriate.
Okay. I was speaking with Mr. O'Connell earlier this morning. He was the witness for the Western Resource Advocates, and he was talking about time of use and to the extent to which, you know, the gas company has to use electricity for some portions of its business. They can utilize electricity at times when it's, you know, most likely going to be renewable electricity, or, and I guess it's just a general question for you. And I assume a time of use rate for gas use does that exist, or is that just not comprehensible for purposes of gas usage?
The issue really on the gas side is the information and metering.
I'm sorry.
In
Is
terms
the-
of information. Yeah, I'm sorry. Go ahead.
Information and metering?
Yes, I'd stop.
Thank
there.
you.
Yeah. Information and metering doesn't exist to really design time of use rates for your typical residential or commercial customer. So it has not been adopted in the industry in general.
I guess I'm just wondering too more broadly though. I mean, do you have, I mean, because, you know, I mean, think about, you know, electrification of vehicles, right? There's periods of time when there's excess capacity. And the question is, well, how do you incentivize a user to use the excess capacity? And we're going through all those kinds of questions. Does something similar exist in the gas supply system? I mean, is it just not a question that you all confront?
Yeah, so the cost differences on the gas side are more seasonal or weather dependent than they are within a day.
Okay.
The gas system, large proportions of the gas system have flexibility to take more gas from off the interstate system and consumed during some hours of the day than others because of the way the system was constructed. So from a cost perspective, there is a distinction as well why you wouldn't derive time of use rates within a day in the gas industry.
Okay. And this may be a question for another one of the gas company's witnesses, but I'll ask you, perhaps you know the answer. How many customer-owned refueling stations for CNG vehicles are there in New Mexico? Do you know?
I don't know specifically. In my experience, there is not necessarily many. What you will typically find is you might have a fleet operator like UPS have their own station. I don't know within New Mexico gas company service territory if any of the fleet operators have their own station or not. That might be a question that's for Mr. Musin.
Okay. All right. Just move on to other. With that. When you did the in the application, the request for the percent change base revenues, and all those numbers come out to 26%. I was just curious how that happened, and why would you have all of these different rates being charged or asked for a 26% specifically? It seemed strange that 26 came up as the number for all of them. Is there some reason or explanation for the pattern? I'm sure there is. I'm just hoping you could explain that to me.
Yes, there is, and I'm sure I mentioned this at somewhere in my direct testimony in terms of the revenue increase. The reason those are all the same is that for rate moderation reasons, I had recommended that no rate class receive a rate increase that was more than 1.25 times the average rate increase.
Okay.
I
Mr. Yardley.
made
if I
that
could direct
recommendation.
you-
Page 31.
Yes, sir. Page 31.
I found it.
lines, yeah, 13 through 15.
Thank you. So page 31, lines 13 to 15, I explained that even though some rate classes, looking at the FACO study itself, would appropriately receive a larger increase, I had limited their increase to 1.25 times 20.8%, which is
Okay.
26. That's why that occurred.
Very good, thank you. And I asked, I think in the bench requests, and perhaps I'll just ask you to clarify for me further still. I noticed as the initial in the application, the impacts of the proposed rate increase for the residential decrease as usage increases, whereas it reverses with the stipulation. And I understood I read your answer, but I'm not sure that I fully followed exactly why. I mean, why would we have, I guess I was wondering why when in the initial application, would there be a lesser impact as volumetric sales increase if the whole goal, I suppose, on some level is to, I don't know, decrease usage and emissions, unless it's, you want people using a lot of gas, I suppose, would be the other answer.
Well, I'd say it's not exactly either of those answers. When you look at the bill impacts and you consider what's happening as usage increases, you need to keep in mind that the impacts in dollar terms do increase for every additional therm a customer uses. It's the percentages that are affected by how the revenue increase is put into a fixed monthly charge versus a usage-based charge. So in the case of the proposal with the application, I was cognizant of the fact that the existing access fee is well below the customer-related costs, which I was discussing earlier with hearing examiner Hurst. And because of that, I put a proportionally larger increase on the access fee. The outcome of that was that the percentage changes in bills as you got to larger bills came down, even though the impacts in dollar terms was still larger. And in my view, when you consider that customers pay for a commodity portion of gas and have some throughput-based charges for the base proportion of their bill, there is plenty of price signal to the consumer to, benefit from reducing consumption. So it was more looking at the customer-related costs and the need to increase the access fee. And that's where the stipulation is different, because the stipulation increased the access fee by proportionately less than I had proposed. It was only, for instance, on the residential class, 40 cents.
Right.
Which is less than the average increase of 9.65% to rate 10. And so that by definition means that the increase to the throughput-based base charges had to be above 9.65%. And the outcome you get is that not only do the bill impacts to larger customers increase in dollar terms, they also increase in percentage terms.
Okay, thank you. And I guess one question I wanted to ask as I was listening to your explanation, I asked Mr. Shell earlier, there was a sentence in his testimony that was something along the lines of assuming gas commodity prices remain constant. And I noted that seemed perhaps problematic, and hearing examiner Hurst also asked about, should we assume that gas prices will remain constant. I mean, as a rate designer, are you, as you're thinking about all this, cognizant of the fact that, you know, the residential customers might be paying more in the future for gas, and how does one deal with that when thinking about sort of equity and fairness? Do you concern yourself with those types of questions?
Yes, certainly. But you do need to keep in mind that we have different types of proceedings for different types of costs. So this proceeding relates to the base revenue cost of service, or the company's revenue requirements, you know, associated with the revenues that it retains. There are separate proceedings, you know, associated with gas costs. And so when I am doing rate design for a base rate case, it is important to hold some things constant to evaluate what the impacts are of the changes that we are proposing. So for instance, on the exhibit, the stipulation exhibit with the bill impacts, in my view, it's best to hold constant, for instance, gas costs or other items that are not base revenue requirements, so that you can consider, is the approach that we're taking for the base charges that are at issue in this case, in the public interest or not. And that's just best done by holding those other items constant.
Yeah, and I'm sure there's all kinds of practical necessities that require you to do that. I'm just thinking about our commenter who began, and every day you read a newspaper, there's a new story about some astronomically new price that consumers have to kind of just deal with. And so I'm more just commenting than anything at this point. Let me move on to your stipulation testimony. There was a sentence I hoped you could help me understand. So if you could go to, this is NMGC 36, direct testimony in support of stipulation of Daniel Yardley, bottom of page 3, beginning at line 25. The sentence there says, these percentage rate increases do not reflect the average bill impact upon customers because they only incorporate the base revenue change and do not account for the commodity portion of the bill, which is unchanged. And I was just wondering if you could clarify for me, what is that referring to when you say the commodity portion of the bill? Is that truly the cost of gas? I mean, is that what you're saying?
Yes.
Yeah, that's what I figured. Ms. Hurst also asked you about the sentence there beginning, saying with your stipulation testimony there at page 4, with the 5% sort of zone of reasonableness, or whatever we could call that. I mean, I was going to ask you a similar question, the one she did. I mean, I'll simplify mine and just say, as you're thinking about, where this range of costs are and what's reasonable, I mean, how much is cost causation principles guiding your determination, or is it really more a feeling of like, well, 5% is a reasonable number, so let's just live in that land?
No, it really is more the cost causation principles that I am considering. And I did try to indicate with hearing examiner Hurst that I probably could have expounded on that. Sometimes I try not to discuss that issue too much when we're talking about a stipulation, because what I might say about it, some of the other parties to the stipulation might not agree with. That said, I certainly did look at when evaluating the reasonableness of the results, the proposed rates and revenue allocation, the results of my initial study, and the 3 groups that we've been talking about in terms of what that study showed, and a fair way to allocate the increase initially, and the fact that the stipulation revenue increases, in my view, are reasonably consistent with what I found when I did the analysis from a strictly cost causation perspective in the FACOS.
Yeah, and you described Ms. Hurst, and I remember listening to that conversation, that I thought it was very useful too. I mean, you talked about how the categories of cost that you identified in the FACOS, which generated that 26 and then 20.5 and correlated later with the stipulation. I mean, that was one example you gave, right? That was, if I'm not mistaken.
Yes,
Yeah.
the percentage increases, yes, correlated, in my view, when you compare them and you line them up.
And
you
that's
can see the point, how to get from point A to point B.
Yes, and that's a concrete example of what you're just describing there, that you utilize the FACOS to sort of evaluate the fairness of the stipulation, because there is no empirical basis to evaluate the fairness of the stipulation. That's effectively what I'm hearing you say.
I'm saying that from a FACOS allocated cost perspective, you do not have the same measuring stick that you have with the application. But in the absence, I think it's reasonable to look at what you have in the application and draw a conclusion that this is a reasonable outcome.
You talked about the customer charge there at the bottom of page 4, and you referenced the rate 10 and then the rate 54. And without asking you to go too deep into the weeds, I mean, how do we get from 12 to 1240 exactly? I mean, what is the basic? I mean, as opposed to say 14, which was the initial application. Why 40 cents is what I wanted to know.
Well, I mean, that's really what was agreed to in negotiations among the parties, the 40 cents. I think what you find often, again, is that frequently consumer advocates prefer not to have the access fee increased by too much. At the same time, from the company's perspective, it's appropriate to increase the access charge by some amount in a case when you're raising revenue. So I don't have the ability to tell you exactly 40 cents.
Mm-hmm.
But again, that doesn't surprise me, having been involved with so many of these cases and often being fairly involved with negotiation of these issues. The 40 cents, would be the kind of number that I would expect to come out of this.
Commissioner Ryan, or hearing examiner Ryan, when you say 1240, is that 12.40?
Yes, thank you. $12.40, and then yeah. Okay, that's all of my questions, Mr. Yardley. I won't ask you. There was other subjects that Ms. Hurst already touched on, so I won't go over that again. Thank you very much, sir.
Thank you.
Mr. Yardley, I actually have one more question with regard to the bench requests. Sir, if you look at your response to the bench request on page 7, and this is gas company exhibit 37. And the question posed, it's question 55. And it has to do with the third quarter regulatory asset report that was filed by gas company. And you refer in your testimony at line 17 that the prior rate case 19-00317 UT allows gas company to book costs for only 3 of 8 types of IMP projects that gas company pursues. That's your understanding?
My understanding is that's true for the regulatory asset. I did not mean to indicate that they're only allowed to book costs for those 3 in general. They can obviously book the costs for all the categories. But with respect to the regulatory asset from the last case, only,
Okay, so
only 3 categories were allowed to be included in the regulatory asset.
So they're continuing to account for whatever other costs in addition to the regulatory asset.
Right. The testimony here on line 16, I'm trying to qualify this statement that it's tied to the regulatory asset and what costs can be booked to the regulatory asset.
Thank you, sir. Do you know why it was agreed that only 3 types of the IMP project costs would be included as regulatory assets?
Well, this was the outcome from the prior rate case, the 29 rate case, which had language in a stipulation related to these type of costs, and the parties decided that they wanted to treat 3 of the cost categories this way and the other 5 not to include in the regulatory asset. I am not sure what reasoning went into why these 3 were in and the other 5 weren't, but that's what the outcome was.
Okay. Thank you, sir. Mr. Haverly. Any redirect for Mr. Yardley?
No questions for Mr. Yardley on redirect.
Very well. Any questions from any of the parties based upon my questions or hearing examiner Ryan's questions? Hearing none, Mr. Yardley, thank you, and you're excused, sir.
Thank you. I appreciate you accommodating my timing for this.
Very well, sir. Well, at this particular juncture, I have 4:20. Does gas company have its next witness ready?
Madam Hearing Examiner, we have Mr. Tom Bullard available to testify right now if you want to start off with him.
Okay. Well, I suggest we have 2 options. We can recess for the day or we can continue on. And in the interest of trying to get the case done, I would recommend we continue on.
That's fine with the company, Madam Hearing Examiner.
Very well. Let's call Mr. Bullard.
All right. New Mexico Gas Company calls Tom Bullard.
Is he? Oh, okay. He's there with you. Very well.
He's right here. We're just going to get this set up right here.
Okay. Good afternoon, Mr. Bullard.
So, good afternoon.
And Mr. Lee, would you swear the witness, please?
Please raise your right hand. You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, sir.
Mr. Bullard, would you please state your full name for the record?
My name is Tom Bullard.
And who are you employed by and what is your position, Mr. Bullard?
I am the Vice President of Engineering, Gas Management, and Technical Services for New Mexico Gas Company.
Mr. Bullard, for you, you have what has been marked as New Mexico Gas Company Exhibit number 8. Do you recognize this?
Yes, I do. That's my direct testimony.
Okay, was this direct testimony prepared by you and at your direction?
Yes, it was.
And do you have any corrections or changes to NMGC Exhibit number 8?
No, I don't.
If I asked you the questions contained in Exhibit number 8, would you provide me the same answers today?
Yes, I would.
And are those answers true and correct to the best of your knowledge?
Yes, they are.
Okay. Mr. Bullard, I'd like you to flip to Exhibit number 9, what has been marked as NMGC Exhibit number 9. Do you recognize this?
Yes, I do.
What is it?
That is my supplemental testimony related to errata number 4.
Okay. And was this testimony prepared by you and at your direction?
Yes, it was.
Do you have any changes or corrections to this testimony?
No, I don't.
If I asked you the same questions as contained in NMGC Exhibit number 9, would you provide me the same answers today?
Yes, I would.
Are those answers true and correct to the best of your knowledge?
Yes, they are.
Excellent. Mr. Bullard, if you'd please go to Exhibit number 10. Do you recognize this document?
Yes, I do. That's my testimony in support of the stipulation.
Was this testimony prepared by you and at your direction?
Yes, it was.
Are there any changes or corrections that you wish to make to Exhibit number 10?
No.
If I asked you the same questions today, would you provide the same answers?
Yes, I would.
And would those answers be true and correct to the best of your knowledge?
Yes.
And would you please go to what has been marked as NMGC Exhibit number 11? Do you recognize this?
Yes, I do. That's my testimony in response to the hearing examiner's June 6 bench request.
Was this testimony prepared by you and at your direction?
Yes, it was.
Do you have any changes or corrections to make to this testimony?
No, I do not.
If I asked you the same questions as contained in this exhibit, would you provide me the same answers today?
Yes, I would.
And would those answers be true and correct to the best of your knowledge?
Yes.
Madam Hearing Examiner, I will represent to you and to Hearing Examiner Ryan that these 4 documents have been uploaded to the Dropbox. And with that, I would move for the introduction of New Mexico Gas Company Exhibit number 8, number 9, number 10, and number 11.
Very well, thank you, Mr. Haverly. New Mexico Gas Company Exhibit 8, Mr. Bullard's direct testimony in support of the application as verified by him here today and was indicated this copy of New Mexico Gas Exhibit 8 was put in the Dropbox. There being no objections, New Mexico Gas Company Exhibit 8 is admitted. New Mexico Gas Company Exhibit 9, Mr. Bullard's supplemental testimony and exhibits in response to order requiring gas company to submit evidence as verified by Mr. Bullard and as filed in the Dropbox without objection is admitted. New Mexico Gas Company Exhibit 10, Mr. Bullard's direct testimony in support of stipulation as verified by him here today as deposited in the Dropbox and without objection, Exhibit 10 is admitted. New Mexico Gas Company Exhibit 11, Mr. Bullard's testimony in response to the hearing examiner's request of June 6th, as verified by Mr. Bullard, as placed in the Dropbox and without objection, New Mexico Gas Company Exhibit number 11 is admitted. Mr. Haverly.
Thank you, Madam Hearing Examiner. With that, I tender the witness for further examination.
Thank you. Good afternoon again, Mr. Bullard.
Good afternoon, Madam Hearing Examiner Hurst.
As the Vice President of Engineering, Gas Management, and Technical Services for a gas company. Seems like that's a lot of jobs, Mr. Bullard.
Sometimes I feel that way too.
Keeps you busy.
It does.
I note that you have a bachelor's in mechanical engineering, an MBA, and you're a PE in New Mexico and Arizona. Is that correct?
Yes, that's correct.
And I guess for a period of time early in your career, you were employed with Allied Signal Aerospace?
That's correct. For the first 9 years of my career, I was employed with Allied Signal in Phoenix.
What did you do for them?
I was a mechanical component design engineer initially. We made and built turbine engines, and then I moved into development, testing the turbine engines.
And were those engines used for what?
For aircraft, small aircraft, propulsion, and for larger commercial aircraft as auxiliary power units.
Was it fun?
It was fun, but as I actually tell new engineers, I find this industry more fun because you get more responsibility sooner.
Ah. So you've been in the natural gas industry since 1993?
That's correct.
As part of your responsibilities, Mr. Bullard, you're briefly describing on page 6 of your direct testimony you're briefly describing gas company's transmission and distribution at lines 8 through 12. You talk about the transmission and distribution facilities operating approximately 1,500 miles of transmission pipelines and over 10,800 miles of distribution pipelines. That's correct?
Yes, that's correct.
What's the difference between a transmission pipeline and a distribution pipeline?
The difference is the transmission lines carry gas over long distances from typically the production center or interstate pipelines to distribution centers. So they're typically larger diameter and operate at higher pressures. Distribution lines are those lines that are within the city streets. They're smaller diameter. They operate typically around 60 pounds, and they deliver gas directly to homes and businesses.
And attendant with those descriptions of miles of pipeline and miles of transmission or distribution pipeline. There are other infrastructure that helps the gas company provide services to its customers, aren't there?
Yes, there are. There are compressor stations and regulator stations, meter stations, and those kinds of facilities.
And a compressor station does what?
Compressor stations are typically on transmission pipelines, and they increase the pressure along the pipeline, which allows more capacity on that line, allows us to flow more gas.
And right now, the compressor stations, are they operated by natural gas? Or
The
electricity?
The majority are natural gas. We do have some electric-driven compressor stations as well. We have a handful that are electric-driven.
And there's a different compression rating for a transmission line as opposed to a distribution line?
There's a different pressure rating, yes.
And go ahead, sir.
Transmission pressures range, at least on our system, range from 300 PSI to 1100 PSI. And our distribution system's pressure range from 2 PSI up to about 200 PSI.
Is the cost associated with a higher pressure more than one associated with the lower pressure?
The cost to build and operate is slightly higher, yes, because they're typically a higher diameter, higher strength steel, higher specifications.
And then what other kind of stations did you say other than compression stations?
Regulator stations, these are the stations that cut the pressure from higher to low pressure to deliver into, say, from a transmission system to a distribution system. We also have meter stations, and many times they're operated together or they're included in the same station, a meter station and a regulator station.
And it meters how much gas is going through?
Yes.
Sir, on page 8 of your testimony, you're responding to the question posed. At page 6, please describe gas company's normal capital expenditure program. And I'd like you to look on page 8 at your testimony beginning on line 4. Additionally, piping and other system components, including meters, regulators, and other equipment, are continuously being replaced and protected with investments such as cathodic protection equipment. Is that correct?
Yes.
What is cathodic protection equipment?
Cathodic protection equipment is the equipment that we use to prevent corrosion on steel pipelines. And it can be either anodes that are buried in the ground connected directly to a pipe, or it can be an impressed current system that uses a rectifier. And
Sorry, it can be an impressed
current system, yes.
directly.
That is, where the current is supplied by a rectifier and the current is applied directly from the rectifier onto a pipeline.
And what does that do?
It protects the pipeline from corrosion. What it does is it creates a voltage differential that forces corrosion to occur on the anodes. They're considered sacrificial anodes, so the anodes corrode rather than the pipe, and it protects the pipe.
So I know in your direct testimony, you go specifically through projects in gas companies integrity management program that gas company was seeking recovery of, beginning at page 22 of your testimony. Is that correct?
Yes.
And as a result of the stipulation, all of these projects are not going to be undertaken, are they?
We will still undertake these projects and complete them, but some of them will be delayed by a year or two.
Do you have any pause with not going ahead and replacing some of these pipes? And I know on page 34 of your testimony and 35, you talk about the beginning at lines 15, as discussed in my testimony in the last case, the company has identified the following areas with the highest relative risk for inspection and mitigation activities as part of the INP. And then you list those things. Then you, at page 35, start talking about where you're proposing to do these things. And like I say, I just wonder if, after reading this testimony about how old they were and how they fail and how they need to be replaced, I'm just wondering if, as the person in charge of all of this distribution and transmission, if when the decision was made to delay some of these projects, if that doesn't give you some trepidation.
When we reviewed the projects that we would likely try to delay, we made sure that we weren't delaying any projects that were needed immediately for safety, and that we made sure that the projects we're delaying would not impact the safety or integrity of the system. And as I said, we still plan to complete these projects. We will make all of these replacements. It's just that it'll be at a slightly slower pace. Some of the projects will be delayed by a year or two.
Do you think there's gonna be, that, for example, when you do replace the projects, do you think that the replacements are gonna have a longevity that the original pipe and other things that you're replacing did?
Yes, that's our expectation. It would have at least the same longevity, if not more.
Because I don't know, I've had to start replacing appliances here in the past 4 or 5 years. And I can tell you that I was told when I was doing my research and going around and looking, I was told that the replacements were, well, they actually laughed at me when I asked them if the washer was going to last 20 years like the one that had been in the house. And they laughed and they said, "Are you kidding? You'll be lucky to get 5 years." So, I haven't been real impressed with, with the potential longevity of at least appliance replacement. And I'm just wondering if you got better news, Mr. Bowen.
I sure hope so. I believe I do.
Okay.
I think what we're seeing with some of the appliances is the increased electronics, and I think the electronics tend to fail. But what we're seeing in the pipeline industry is that materials have gotten better, construction methods have gotten better. We've gotten better at our performing maintenance. So the expectation is that they will last just as long, if not longer, than what we're replacing.
And I was wondering that because in reading your testimony, I guess I was quite surprised to find out, and I didn't remember this from the rate case I did a number of years ago, but I did not recall that there were components of the system that you didn't have any records at all of inspections on. Isn't that correct?
Well, at least not sufficient records. That's correct. Some of the pipe that was installed prior to 1970, which is what we call pre-code pipe, which is before regulations had come into existence, requiring that you keep records, that you have records of the material, and that you have records of the pressure testing. So some of those pipes and a large number of that pipe, we do not have sufficient records for. So that is what's really driving some of our IMP efforts in terms of re-verifying those records.
Well, and I would note on page 49 of your testimony, for example, that line 16, you say gas company does not have a single electronic-based system to record all of the functions. So I was kind of wondering, even if you had the records, if you don't have like a computer program or whatever, how helpful is it going to be?
Well, it is difficult. We do have paper records of a lot of our pipes and systems. And so we do have to search those records frequently to determine what the history of the pipe, and to determine if we have adequate records to confirm the MAOP. We are also in the process of
MEOP.
I'm sorry, MAOP, an acronym for maximum allowable operating pressure.
Thank you.
Of course. But we are in the process of developing an electronic system to house these records. We've also started a process to scan in all of the paper records so that now we will have them electronically in a computer database.
And I also find it interesting that that the pipeline inspections are called leak surveys.
One of the pipeline inspections that we perform is called a leak survey. That is correct. And
Yes.
it
Go
is-
ahead, sir.
Its specific purpose is to look for leaks, and we use detection equipment to locate and pinpoint methane leaks on our pipeline.
And I thought that part was pretty cool, especially the pigs.
Yes, we also use a different type of inspection tool. That's an inline inspection tool. We call them smart pigs that we can put in transmission lines and run them down the transmission lines, and they find anomalies that then we can address before they become problems.
I'm seeing like a
Is that PIGS?
Pigs?
Yeah.
Yes, PIGS.
and it stands for
It doesn't, it stands for pig.
a pig. And
They're called,
if you just defined a pig for the record,
so a pig is an inline tool that is used in pipelines to either clean the pipeline, and sometimes they're called smart pigs, and they're used to inspect the pipeline. And they've got electronics that are on the unit itself, and this unit is sent through the pipeline, providing data about the pipeline. The reason they're called pigs, I'm told, and this is before my time, is that the original cleaning pigs were just wire brush pigs that they would send through the pipeline, and it made a squealing noise like a pig. And this is how they became known as pigs.
well, I'm envisioning like the smart pig is something like in a James Bond movie where, where they, there's this self-propelled little machine that goes through the pipeline. Are the smart pigs really that big?
Yes, I mean, that's a good description. On a smart pig for a 20-inch pipeline will be somewhere from 16 to 20 feet long.
And it's self-propelled?
It's propelled by the gas moving through the pipeline.
Oh, so the pig can be in the pipeline when the gas is in there?
It has to be. That's how it moves through the pipeline. The gas,
Oh.
you need the gas flow to move the pig. Yes.
Because I guess I thought that that there were some pigs that were actually that they cleared the gas from the pipeline and had some kind of either projector to launch the pig through the empty pipeline. No?
So there are two other types of pigs that are used in the industry. One is a robotic pig. It is self-propelled. We do have launchers and receivers for both of these types of pigs. The robotic pigs tend to be used in smaller diameter pipelines. They're not widespread in the industry. They don't travel as far down a pipeline. They're really only good for very short distances and small diameters. The other type of pig that is sometimes used is a wire drawn pig, and that requires the pipeline to be blown down completely, and it's pulled through the pipeline with a cable. And again, it's typically only over very short distances. So the most typical kind of smart pig or inline inspection tool is one that uses the gas flow to propel the pig down the pipeline.
Okay. Interesting, thank you. So back to these leak surveys. So this morning I was asking Mr. O'Connell, and he was testifying about the leaks and the damage that the leaks do with the gas, I guess, in the air. Well, that might be of some importance to gas company. Is that the main reason that you're doing these leak surveys?
No, the main reason is for safety. We want to make sure that the system is safe and that we repair any leaks that we find that are hazardous.
Can there be non-hazardous leaks?
Yes, there are, although we have now undertaken a program to repair even non-hazardous leaks, but a typical non-hazardous leak would be a leak that is away from any population and is a very, very small leak, one that we call a fizzer in the industry. It's a very small amount, and it's
a fizzer.
Yeah, fizzer. A fizzer. It's and it's way out. It's out in the boonies, for instance, and it's not accumulating. That would be a non-hazardous leak.
If somebody like threw a cigarette there, could it explode?
Not likely, no. Not in the amounts we're talking about.
Okay. I mean, is that the? I mean, plus, I'm sure you don't want your gas leaking out. That's not cost effective, but
that's not right, or environmentally friendly. Either one.
Right. Either one of those. But the main, the main issue is danger of explosion.
Danger of ignition. Yes. So that's
okay.
That's the concern, is that you have an ignition, you have enough gas, and that you have an ignition source that can ignite the gas. And so again, when I speak of non-hazardous leaks, these are leaks that the gas volume is such that it's so low that it would not ignite.
And on the topic of safety, you testify beginning at page 58 of your testimony about new employee positions. And you talk about compliance project managers for pipeline safety management, and a trainer and an analyst and a coordinator, and an environmental employee to support the right-of-way and environment department, and a gas supply manager. Is that correct?
Yes, that's correct.
And with were these part of the 32 potential new employees?
Yes, they are.
And my understanding is the request for the revenue for the 32 potential new employees has gone away with the stipulation. Is that correct?
Well, as part of the stipulation, or living within the stipulation, we are delaying some or many of these 32 employees. I would, and really, I think, as Mr. Shell mentioned, our focus has become on retaining our current employees and filling our current vacancies. But that these employees are still needed, and that we will likely hire some or most of them over the next couple of years.
Well, I just have some concerns when you're talking about safety and you're saying you need some more safety employees. And, you know, the potential that the safety employees were included in the 32 positions that basically there's not going to be revenue for.
Well, as we will continue.
Should I
to
be
evaluate-
concerned?
I'm sorry, no, I don't think so. No, you should not be. We will continue to maintain a safe system. We will make sure that we're doing the things that we need to do for safety concerns. And we will continue to evaluate these positions. As we work through hiring our current vacancies, we will evaluate priorities and likely will over time fill these positions as well.
Were the employees that got poached by the lab, were those your employees?
I did have a couple of engineers but I think the ones that you're speaking of were operations employees specifically. The ones that were discussed in testimony were operations employees. And I think they were service technicians primarily. So no, they were not my employees.
Okay. Sir, your testimony at page 63 is on discounted transportation rates. And at line 5, you say gas company currently offers 10 discounted rates for transportation services. Do you have customers in all 10 rates?
Yes.
And I note on page 64 of your testimony, beginning at line 1, you say, pursuant to Rule 660, gas company may offer discounted transportation rates on a non-discriminatory basis in order to compete for the business of a transportation customer or end user. Then you go on to testify about the 3 different circumstances by which gas company might consider offering that customer a discounted transportation rate, including retaining load, preventing bypass, and increasing throughput. Is that correct?
Yes, that's correct.
Is there a particular volume of gas that the customer would need to transport to get one of these special rates?
No, there's not a particular volume.
Okay, so you don't look at it, oh, it's a little customer or a potential big customer when you make that determination?
Well, we look at the customer as a whole, but no, it's not. It's really just whether or not they fit into one of these categories.
Okay. The category of increasing throughput, what differentiates that customer from any other customer that just wants service?
Typically, that's a large volume customer that has the ability to increase their operations if there's a discounted rate at a certain rate that makes it economically viable for them to increase their operations and thus their throughput.
So then in that particular category, you are looking at the volume that the customer moves or potentially could move, right?
Yes, that's correct.
But also who they might be able to, for example, if it was like in some kind of industrial area, and if that was a potential customer, and then they might have somebody next to them that you could get to, right? I mean, is that, I guess I'm trying to understand this increasing throughput. You describe it as a customer requires a discount in order to bring new business onto the system. And I'm just wondering if it means that that customer might be new, they might increase volume, or if you're looking, I guess I'm kind of looking at it in terms of, like running a line and being able to add more customers than that one. Is that part of the consideration or no?
Typically, it's not. No, it's typically a customer that's already on our system. If we're going to run a line, then we would ask for a volume commitment. So that's usually a little bit different.
Okay. And you say on page 65, in answer to the question posed at lines 14 and 15, what is the benefit to gas companies' other customers of securing business at these discounted rates? And you begin your testimony at line 16, customers to whom service is provided at discounted transportation rates make important contributions to fixed costs, which benefit other customers. Any revenue that is received from the discounted transportation rate customers above the variable cost of providing the service helps to reduce the revenue requirement in a general rate case and therefore reduces the revenue that would otherwise be needed from other customers to cover the company's cost of providing service. Correct?
Yes, that's correct.
And how would you define this particular contribution?
Well, I think on my next page in the testimony, it's about 2.7 million total in revenue from these discounted transportation customers, and I guess the theory is that if these discounted rates were not offered, these customers would not be there. They would not take gas service, and so this 2.7 million would fall to the rest of our customers.
But I'm just wondering, out of do you know what the annual revenue requirement is?
The total for the company?
Yeah,
No, I do not. That's finance stuff. I try to stay away from that.
I was just wondering whether or not you consider $2.7 million out of potentially hundreds of millions of dollars to be a significant contribution.
Well, it's a contribution that would fall to the rest of the customers if it weren't there. So
Okay. And with the transportation customer, is the only service that you provide is allowing them to use your pipeline?
that is that's the main service we provide. We're also we're the backup. We're the supplier of last resort. If they don't get their gas supplies, we supply the gas to them.
Okay. On page 66 of your testimony, the question posed at line 10, were discounts provided to any transportation customer lower than the system average variable cost? And your answer was no, correct?
Correct.
Why not?
Because we're required not to. The requirement is that we don't discount any lower than the system average variable cost.
And that's pursuant to the rule?
That's correct.
And then a little further down on 66, the question posed at line 15, has gas company implemented any new discounted rates for transportation service since its last rate case? And you begin your answer at line 17 saying that gas company anticipates modifying its discounted contract rate with Holly Frontier Refining in the spring of 22 to add volume to Holly Frontier's petroleum refinery in Eddy County. Do you have any update? Did that actually occur?
Yes, it did. That is in place and in service now, and we are providing those volumes.
And are you providing it at the cost that you set forth in your testimony?
Yes, we are.
Do you have any projection on how that's going to affect revenue?
I don't, but the finance team has taken that into account as they projected revenue.
Do you think it's going to increase that 2.7 that you testified at the top of that page?
I believe so, although we have had another customer that shut down, so there's some offset, but I believe that customer that shut down was already factored into that 2.7. So yes, this should increase that.
And are the customer you're referring to is the Siniza refinery
Yes, that's correct.
that you testify about on the bottom of page 67?
Correct.
Is there a chance that that could open back up?
Guess there's a chance. I'm not aware that they have any plans to open back up.
Is there a chance somebody else could buy it and open it up?
Yeah, I guess there's a chance, but I'm not aware of anybody considering it or looking at it.
Okay, I just wondered if, you know, if the one that shut down, if there's, is gonna be a potential customer there. Your testimony in the middle of page 67, I like the brief answer on line 13, yes. Question posed, are each of the discounted transportation rates in effect at this time just and reasonable, and do they benefit other customers? And you say yes. And why is that, Mr. Buller?
Well, as I explained in the previous testimony, they're all above the variable rate. And if these were not in place, it's likely that some of this or all of this volume would go away. And so then that revenue requirement would fall to the other customers.
Okay. And page 68 of your testimony, you're talking about a compressor Terra. Correct?
Compressor care?
Terra?
Thank you.
Yes, sir. Is that correct?
Yes, that's correct.
And you say on page 68 at line 17, compression facilities utilize a large amount of gas and are important customers. So when you say they utilize a large amount of gas, are you saying that they actually use a lot of natural gas that you're supplying to them?
Yes, that's correct.
And you say then, additionally, these facilities are owned by gas exploration and production companies, which may be, many of which are responsible for producing the processed gas that New Mexico, the gas company uses to serve its customers. Correct?
That's correct.
So you're not only providing gas to them, but they're providing gas to you?
So they provide gas to the interstate systems, where we get our gas off of, and there are a couple of them that we do take gas off of as well.
Well, if they're producing gas, why don't they use their own gas?
Their gas is unprocessed. So what they're looking for is processed gas or pipeline quality gas. And so these compressor stations typically are moving gas from the production fields through gathering lines to a processing facility. And so we may be closer to them than the outlet of the processing facility. And so we have pipeline quality gas that they can use rather than using the unprocessed gas.
So where are they getting the gas from?
From the production fields, typically in either the Permian Basin or the San Juan Basin.
Are they utilizing a process known as fracking?
The production companies are at these facilities, all they're doing is moving the gas from the production field to processing plants. The production companies that are producing the gas do use fracking. Yes.
Well, I think due to the lateness of the hour, I still have a few questions for you, and then believe that hearing examiner Ryan has some questions for you. So I think it might be prudent at this point to recess for the evening and start back up at 9 tomorrow, Mr. Bullard, and we'll continue your testimony at that time. I believe based on the discussion that we had last Friday, after the conclusion of Mr. Bullard's testimony and subject to any update from staff, potentially on Ms. Ramey's availability, we would then go ahead and proceed with gas company witnesses, Wasim, Sanders, Sanchez, Jaramillo, Wilcox, Jones, and Moore. If we get through all of those witnesses, which optimistically we could. So if no one has any questions, thank you all for your participation. And thank you, Mr. Lee. And we will recess for the evening and resume at 9 o'clock tomorrow morning. Attorneys should be on the Zoom at 10 till 9 to discuss any procedural matters or scheduling that we might need to do. So thank you all very much and have a good evening.
Amen.